For citing. Yes.
May I please? My lord, may I permitted to bring on record an additional affidavit
In which item?
in item number 28.
File to Aisha?
Please, my lord. My lord, I beg to mention three interlocutory applications for withdrawn, my lord. Lord, I may pray that
Mention should be in the before the.
my lord, it is not by Honorable Justice. My lord, tomorrow, my lord. Grateful.
May I please, Your Lordship? Lordship, I beg to mention item number 19. In this case, Your Lordship, I would to have filed additional affidavit.
Have you filed a
No,
MACT
today,
case?
by today, Your Lordship.
Have you filed an MACT case?
Yes, Lordship.
MACT.
May I please, Your Lordship? Lordship?
When the matter takes.
Lordship. May I please, Your Lordship? Lordship, I beg to mention.
Now you have filed an MACT case.
Yes, Lordship. In this
This
case,
is not an
If your
accident
Lordship-
related to some extremist activity.
Yes, Lordship.
And we have already decided that.
Decided, Your Lordship.
More is required.
In this case, Your Lordship, I have in dispute regarding that issue which has been decided by the coordinate bench. Your Lordship.
You take
If Your
it up
Lordship
on-
allow me,
you-
then
You take it up on appeal and get it restored.
Lordship can refer to largest bench also. Otherwise, Lordship can allow me, I will file a written argument, Your Lordship.
No. Today you argue.
Lordship, I'm sorry.
Lordship, I beg to mention item number 23, Lordship. Lordship, due to some personal difficulties, my senior counsel is out of station, Lordship. Adjourn the matter for the Lordship.
Oh, we had heard this matter at length. Contractual appointment. Where is Mr. Chaudhary?
Mr. Chaudhary, due to some personal difficulties, Lordship, he is out of station. For the last night, he was ready for argument. But due to some medical, he has to go
Medical.
for medical issues.
A prayer is made on behalf of Mr. A.Y. Chaudhary, Learned Counsel for the petition for an adjournment in the matter on the ground that he is indisposed. So prayer is not objected. Have you informed the other side?
No, Lordship.
Then inform and then make a mention.
I will inform Lordship.
When the matter is called up, renew your prayer. Yes, madam.
May it please your Lordship, with the consent of the other party, I beg to mention item number 7, Lordship. I seek for an adjournment here, Lordship, because this matter has been listed after 4 whole years, Lordship. So we need some time to seek instruction, Lordship.
You are appearing for whom?
Lordship, for the petitioner.
Yeah.
Lordship,
The prosecution sanction has been granted.
Lordship, I am not fully aware,
Okay,
Lordship.
we'll have the respondent's answer to that.
Lordship.
You be here when the matter is called up.
May it please your Lordship. Lordship, with consent of the other side, I beg to mention item number 24, Lordship. I have circulated the adjournment
You
slip.
have circulated up.
Lordship, Learned Counsel, Mr. R.S. Mishra is out of station, Lord.
Okay, no adverse order would be passed. There is no affidavit filed in the matter.
No, Lordship, but
So we'll have them. We'll ask why the affidavit is not.
interim is there, Lordship.
So we'll continue it. When the matter is called up, renew your prayer. I'm not
Right.
passing any adverse order. Don't worry. Yes.
May I please, Lordship? Lordship, I am paying for listing of a motion matter for tomorrow, Lordship.
Cannot be taken up.
No.
What is the issue?
Lordship, matter is the service tax matter.
Wait, please, Lordship. Lordship, I beg to mention item number 15, Lordship.
15.
15, Lordship. 15.
50.
15, Lordship.
15, yes.
Lordship, I am appearing for the petitioner, Lordship. Lordship, the Learned Counsel, M. Soikia, is out of station for some medical
M.
emergency.
Soikia.
Yes, Lordship.
But M. Soikia is not in item number 15.
15, Lordship.
Sorry. Rejected. You prepare your file. Yes, Mr. Chetia, what is happening? Why?
Well, I may, for your Lordship, ask me a question. Under very peculiar and compelling circumstances, what is going on? When I filed the writ petition, my lord, they came to know that the writ petition has been filed by another director. The lady director which she was appearing, they informed them that we will call you for 2 months regularly. And she's called at 11 a.m., asked to sit up to 8 p.m., 3 days. Again, she has been asked to on Thursday. And the only pressure, my lord, I will not say, utter the word, my lord, in the court, ulterior motive. Purely ulterior motive, my lord, pressurizing, and 5 days back, the accountant was beaten in the inside room. He filed an FIR. Thereafter, under pressure of them, threatening them, he has to withdraw the FIR. But this is going on. Let them pass any order.
Mr. Chetia,
Lord,
once you issued a summon to the company,
my lord,
you are issuing the summon to get some information,
lordship,
right?
Lord.
Where is your material that the authorized director and the accountant
Lordship.
are not in a position to give you the details that you are seeking for, and the other directors are required to be examined? Where is the material? Where is the finding?
My lord, in fact, the summons, my lord, does not disclose. My
No, summons here to the company has responded to
Lordship,
their
lordship.
authorized representative.
Lordship.
Now, the authorized representative is not cooperating in the matter with you. Where is the material?
My lord, to that extent, I have to take
You
instruction.
take your instructions, but don't give effect to this.
My lord, I'm saying, the dispute is about the classification of the item, whether it will be taxable at 5%, 18%. And all the statement, whatever.
You have also taken up for reversal of the.
We have paid, reversed and paid. And even if they are agreed, they pass, let them pass the adjudication order. I have no grievance. I'll go in appeal or whatever I do.
Mr.
But you-
Chetia, I want this answer.
Lordship.
What is the reason?
Plus some message must go from the court.
So
my lord.
we'll have this. We are keeping it in the motion stage only.
Lordship.
Heard Dr. A.K. Saraf, learned counsel for the petition. Also heard Mr. S. Chetia,
Lordship.
learned standing counsel, GST, appearing for all the respondents. Also, the grievance of the petitioner in the present proceeding is to the effect that on a investigation being instituted against the company, petitioner number 1 company, comma, the directors of the company had authorized one of the directors to appear before the GST authorities along with the accountant of the company. It is projected in the petition that there is no default committed by the authorized director as well as the accountant in appearing before the GST authorities and cooperating with them in the investigation underway. Also, it is the further contention of the petitioners that without bringing on record any material to demonstrate that the company is in no manner cooperating with the investigation of the matter, comma, now have issued the impugned summons directly to the directors of the company requiring their presence before the
Number
GST.
2 also.
Huh?
Petition number 2.
To the director of the company, that is the petitioner number 2, to appear before the respondent authorities. Also, the materials brought on record reveal that the company is seen to have been cooperating with the GST authorities in the matter of cooperating in the matter with the GST authorities. However, it is not discernible as to why, in spite of such cooperation being extended to by the petitioner number 1 company, summons have been now issued to the petitioner number 2 for appearing before the GST authorities. Also, in view of the above, posed with the above situation, Mr. S. Chetia, learned standing counsel, GST, submits that he shall receive instructions he shall complete his instructions in the matter and apprise this court about the reason as to why summons were required to be so issued to the petitioner number 2 when the petitioner number 1 company was already cooperating with the GST authorities in the investigation of the matter. The said instruction be either brought on record by way of filing an affidavit and or by way of a written communication issued by a competent authority of the GST, a competent authority of the respondents. Also, when?
Lordship, next Tuesday, 17th.
Also, till the next returnable date, the impugned summons issued to the petitioner number 2 shall remain stayed. Also, registry to list this matter again on.
Well, what I will request, my lord, the statement which has been recorded by them from the respondent, this, my lord, that may be brought and shown to your lordship, my lord, so that your lordship will come to know that what statements.
Let us go.
And my lord, the coercive measures against the director which is appearing, from 10 o'clock, 8 o'clock, the lady
We'll
director.
put it, we'll give a short date when,
Lordship, next Tuesday, Lord, 17th.
17. 17, list the matter on 17 to 2025. Further orders as would be called for in the matter would be
But
passed.
at least my learned friends should communicate to them that not to, my lord, the,
I'm coming to that.
my lord.
Registered to list this matter again on so and so. Also, at this stage, Mr. Dr. A.K. Saraf, Learned Counsel for the petitioner, has submitted that the GST authorities are harassing the director as well as the accountant who have been authorized to appear before the GST authorities who have been authorized by the
He can
petition.
appear already.
Dr. A.K. Saraf, Learned Senior Counsel, appearing for the petition at this stage, submits that the authorized director as well as the accountant of the company, who have been so authorized to coordinate in the matter with the GST authorities and who are regularly coordinating with the GST authorities, are subjected to unwarranted harassment at the hands of the GST authorities. Also, Mr. Chetia shall also receive instructions in this connection and would also advise the respondents that unwarranted harassment is not to be
Meted out, my lord.
meted out to the authorized director as well as the petitioner as well as the accountant of the company in violation of the procedure as mandated in this connection.
Highly obliged.
Lordship, I'm appearing for assessment number 2 and 3, my lord. Union of India, my lord. I do not.
Report Likhiba. Mr. S.S. Roy, Learned Counsel, appears also heard Mr. S.S. Roy, Learned Counsel for the Learned CGC, appearing for the respond number 1, and Mr. S. Chetia, Learned Standing Counsel, GST, appearing for the respond number 2 and 3. I don't know.
Lordship may communicate, Lordship may issue an true copy of the order by today itself.
I am uploading it by afternoon.
Lordship.
Moment I get down, I will sign it.
It's not by learned friend.
You
can-
download
I'll communicate today itself. Lord.
Telephonically also, you can communicate it one
My
at a
lord.
time, my lord.
I only want to know.
My lord,
Maybe
my lordship.
Mr. Saraf, those two are not even cooperating with you, not even giving you
My
anything.
lord, my lord. I'll
If
have
that
full
is that,
instructions.
show me
Lord.
the material.
Lord.
And the statement recorded by them.
That Mr. Chetia, see what is the
My lord.
CD or something you have for my satisfaction.
My lord, my lord. We'll
You
furnish.
need to
Lord.
counter the argument of Mr. Dr. Saraf that you are unnecessarily harassing.
Lord.
Whatever materials are there, place it.
All statements have been recorded, my lord. Everything recorded.
But these are all matters of records, right?
Lord.
You pass an order.
Lordship.
What is preventing you? You are actually delaying the exchequer from the benefits that the
No,
exchequer
my
is to
lord,
get.
I must say, I should not say, this is not exchequer, my lord. This is ulterior motive.
No, Mr. Dr.
My
Saraf.
lord.
Let's hold that they are bona fidely doing it. What are they doing it? No, Mr. Dr. Saraf, I understand. But what are they doing really?
Only
It's not a
harassing-
criminal investigation into a murder case.
So that there's a breakdown and, my lord, whatever they say. it should
You
be done.
are protecting the interest of the exchequer. The earlier the money comes into the exchequer, the better. Why are you delaying it? I've seen it. It's there for a long time now. You're not able to come to a definite conclusion.
Lordship.
Have you issued a letter to the direct or the petitioner company that your directors are coming, everything is there, but these particulars have not been given to us? Have you?
Lordship, with the instructions only, Lordship, I'll make.
We'll furnish all the particulars, whatever they ask. But they
No,
ask for,
They have not given you any.
no, they ask for what is your fixed deposit? How much property is there? What is this in GST?
No, that is not part of record, Lordship.
I am saying on the, my lord,
That's why I have not referred to that. It's not there. So I have not referred to it. But the coercion part, there is something.
Certainly, Lordship. Certainly.
I'm highly obliged, Lord.
I'm obliged, my lord.
Dr. Saraf, tomorrow there is one delivery of order. I'll
Well-
do it at 2 p.m. So it will not be.
But whenever it's convenient,
I've done it. Little bit
no
is left.
problem at all, my lord.
If I finish it today, tomorrow too I'll.
No problem at all, my lord.
I'm obliged. my lord.
Please, Lordship.
The respondents were asked to file affidavit on the last occasion also, that is dated
Lordship,
4/12/2024. Last chance to file affidavit,
the
Lordship.
agreement was called for, your lordship. The agreement we couldn't trace out, but the agreement is in the MMC rules,
Okay.
completely there.
Forget the affidavit. This is a 2014 matter. Yes, madam. What is it? There are three cases. One
Yes,
with
yes.
regard to overestimation of the quantity of sand. Second is show cause. Third is with regard to the fresh LOA that was issued, right? Now, these are the three cases. So we'll have to see whether there is any default on your part. Okay, take us through these matters. We'll pass orders. You show me the default. Yes.
Lordship, my humble prayer is to increase the security deposit amount.
No, you'll have to establish why. Madam, you'll have to establish that aspect. That why the security deposit, because they had forfeited, they cancelled the agreement or the contract, right? They rescinded the contract. So now if the contract is rescinded, a normal thing would be that you are not entitled to the security deposit. Now, according to you, why are you entitled? If you are not prepared, tell me, I'll take it up another day. If you're prepared, kindly, I'll be very happy to. 2014 matter, we don't want to keep it pending. Yes.
Grant me some time, Your Honor, Lordship.
On the prayer of Miss
Adas.
Adas, learned counsel for the petitioner, registry to list those matters again on Thursday. By slip.
Always.
Ma'am, come fully prepared with that. We are ready. You also
Yeah.
guide us. Take us. Mr. Counsel, before you start off, there were basically two prayers. One is regularization that you forget. Next one is EPF. And the third one is ESI. Now, EPF coverage has been extended to you.
No, Lordship, that is my query. They have extended the EPF coverage to the employees getting under the slab of 15,000. My query is
That it should be also extended to the persons
what about
above.
others? Yes.
Okay. But then ESI,
ESI, Lordship, it can be set aside because now the employees have been
given that 5 lakhs thing,
Lordship.
5 lakhs.
No, that 5 lakh different. Now they have been covered under the Mukhyamantri Lok Sabha Arogya Yojana recently.
So these two
So,
prayers
prayers
gone,
were gone.
only left is EPF.
EPF. Lordship.
Yes.
Lordship, my humble apologies, Lordship. Can this matter be taken after some time? Because the main counsel is Counsel Bigo. He's on legs, Lordship.
Mr. Roy, you are appearing for whom, Mr.?
For the respondent number 5, ESIC.
ESIC has given up.
Actually, it's not covered also.
It's given up. Yes, Mr. Roy,
For respondent number 6.
you are the main man, EPF.
Well, yes,
EPF.
Lordship.
Now, EPF, he says that it is already extended to persons below the maximum slab, 15,000. Now, what about the others? Are they also to be brought in?
My lord, my instruction is that I got, my lord, in 2000, the last.
No, just a query from this court as to whether, see, in an organization, there are persons who are earning 15,000 or less.
No,
and there are
more, Your Lordship.
Oh, I'm coming. Please let me first my. Oh, you asked the query.
No, Lordship. I'm sorry.
And there are employees who are drawing 15,000 plus. Now, both have to be brought into the EPF coverage.
No.
Only persons having
15,000 less.
Less.
And 15,000 more, my lord, now
It's
it's not there.
optional.
No, that's not.
It's optional.
It's
I cannot force.
no. Both employer employee, there are procedure, my lord. This is accepted.
So 15,000 below
Less.
are giving EPF coverage to that extent satisfied. What more is left?
They will show the which is the rule.
Which rule? You take out the EPF Act, read it. We'll take it up after some time. Come back and tell me. Mr. Gogoi will appear. Yes. Okay. Your name, Mr. You are Mr.
I am.
Mr. Ahmed will take it up after some time. So we have noticed your submission that the EPF Act requires coverage only to the extent of 15,000.
Lordship.
Whenever Mr. Gogoi is here, ask Mr. Ahmed to be here, we'll take up. Mr. Roy, I don't think so. Your presence would be required. If you are here, nothing like it. But I'll not trouble you.
Lordship.
Yes, where is your additional affidavit?
May I please, your lordship, kindly pass over the matter for time being. Arguing counsel is in kept for hearing matter. It might take time. Thank you, lordship.
Yes, what has happened now?
Lordship, I respectfully seek some time.
Sorry.
He was allotted to the surplus.
He is getting. But there is an affidavit which says that they have also cancelled his. Your license is not cancelled.
No, Lordship.
As per instruction from lordship, he as per the honorable court order by the it is otherwise lordship, it is stated as per.
Your affidavit states that that has also been taken up for cancellation. You are Rattanboro.
Sir, actually, I'm very new to the profession. Lordship, I'm new to the profession and I'm not acquainted with the facts that much.
How long have you been in the profession?
3 months, Lordship.
Okay. Have your seat.
Lordship, there is a affidavit from our side, lordship. But in our file, lordship, only instruction is there.
You go through the affidavit.
Lordship, I'll go through it.
We'll take it up after some time. Petitioner is also not there.
I'll go through it.
Take it up. We'll take it up after some time. And ask your senior whether your client is still continuing with that fair price shop. Just have that instruction. Yes, Mr. Gogoi.
Lordship, 7.
The
Lordship,
prosecution sanction was
lordship,
granted.
that part in the affidavit, it was filed on.
That
Lordship.
much it stops at that stage only.
Lordship, after that, lordship, matter was come for first time, lordship. That's why, lordship, make reasonable time, I will apply.
No. Only thing we require is
Whether
here,
it was prosecution
if
sanction or
the
granted.
prosecution sanction has been granted and the
Lordship.
charge sheet has been filed.
Lordship.
That's the end.
Lordship.
Next day, law will.
Lordship.
When? Monday? Tuesday.
Tuesday.
Mr.
Lordship, on Thursday or Wednesday, Thursday.
Wednesday.
Thursday.
Heard the learner counsel for the parties. Also, it is seen that the affidavit, it is revealed from the affidavit filed by the respondent number 7 on 16/8/2017 that the investigation in the matter was complete. However, the charge sheet was not filed in view of the fact that the prosecution sanction at that stage was not obtained. Also, Mr. K. Gogoi, learned additional senior government advocate shall, on the next date of listing, apprise this court as to whether the prosecution sanction against the respondent number 9 herein and other accused persons have been granted by the competent authority, and as to whether the charge sheet has already been filed filed. Also, he shall also apprise this court with regard to the status of the trial, status of the criminal proceeding instituted against the respondent number 9. Also, restrict to list this matter again on
19, Lordship.
Okay.
19 or 20, Lordship.
No, 19.
Thursday, Lordship.
19 to 2026. Who doesn't? 18 to 19, there is much.
Lordship.
18 to
18.
You also have your instructions, madam.
Lordship.
In the meantime.
Lordship, as per our verbal instruction, a divisional office is already established in Bongaigaon, so the matter has become infructuous since 13th of June 2022.
Mr. Mahmood, you are appearing in this matter. The instruction is that the divisional office has already been installed.
Yes, relief already provided, so it may be treated as withdrawn.
Mr. M.U. Mahmood, learned counsel for the petitioner, on instruction submit that the respondent authorities have established a divisional office of the irrigation department in the district of Bongaigaon.
Yes.
Also, accordingly, he submits that the present writ petition has been rendered, has become infructuous. Also, in view of the above, also the said prayer is not objected to by Miss
Tin Lung on behalf of Arimdas,
learned counsel appearing for
Water Resource.
Water Resources Department, Irrigation, Noida, Water Resources. For irrigation, litigation, and water resources. And Mr. N. Das, learned government advocate appearing for
8.
for the respondent number 8. Also, in view of the above, the present writ petition stands dismissed on having become infructuous.
Obliged.
None appears for the petitioner on call. Mr. M. Chettiar, government advocate, is present. It is seen that on the last two dates of listing, that is on 2/5/2025 and 15/5/2025, there was no representation on behalf of the petitioners. Why are they not appearing? Maybe the matter has been resolved.
Whether such sheet has been filed or not, at that time investigation was going on, my lord, 2018, my lord.
For the ends of justice, registry to list these matters again on Thursday. Why slip quit? Don't want to dismiss it, let's see.
My instructions, Lordship, this contract was not awarded by this unit and the payment was not also made by this unit.
Mr. Purkhaisto, it's not
Lordship.
time for.
2.3, Lordship.
We'll take it up after some time, next round. None appears for the petitioner on call. For the ends of justice, registry to list this matter after 4 weeks on a date to be fixed.
First one, number 2, madam. So done with 4 weeks time to file my affidavit.
You are for Nobin Devnath. Yes, what do you say about this? That agreement that has been entered into?
Well, I will put it on affidavit, my lord. What will carry me 4 weeks time, I will put it on it.
Why?
It had been settled in the local lot, my lord.
Huh?
Local lot.
I know, it was settled in the local adalat. The claim application reveals the name of the petitioner as one of the claimants. Page 70.
Yes, sir.
Right?
Yes, ma'am.
Zulekha Bibi.
Yes.
She is the
Claimant
mother
number
of the
3.
deceased.
Claimant number 3.
Now, when the compromise was arrived at, where is her presence there?
All the claimants are present, but there is no signature. I have seen it, my lord.
No, it does not say
Page number 26.
26.
All the claimants are present, that it is there, but there is no signature. That
No, it does not. That is just a format.
yes, but the signature
So
is
that
not there.
signature should be there.
Signature is not there.
So how can this be?
Well, let me put it on affidavit, my lord. Let's after lots will listen.
Money has been withdrawn.
The money?
Money has been withdrawn. Money has been paid by the.
Long back, man. This is 14/9/19.
Now, what happened in this case, my lord? The lawyer, without making us a party, my lord.
No.
Party
You are
is
a party. In the claim, you are a claim petition,
Claim
you are a
party.
party.
But we have nothing was started.
Claim petition, page 17,
Yes.
you are a party.
Yes.
But when the compromise was arrived at,
I was not a party.
you are not a party. And it is also not recorded that you had given a power of attorney or a
Right,
authorization
exactly.
to this lady. So
The lawyer is aborting the service.
No, I am appearing.
You are appearing.
Yes, yes.
Against not.
Yes.
Devnath.
Yes.
oh, you are the advocate.
Yes.
Yes.
Now the records have come. Records have been called for recordization. You are appearing for
Respond number 3, insurance.
insurance. How did you arrive at this compromise without the presence of all the claimants? What is the basis? Mr. Counsel, now you'll also have to make a payment to this. How have you?
Our part of the payment we have.
No, how have you? You have gone for a compromise. Where are the other claimants? Or where is your plea that the other claimants, the Minjuma Begum was representing all the claimants? Where is the material?
She may grant us some time, Lordship.
We have been granting you time only from the day one.
No,
From
Lordship.
2020, matter is pending.
20
Matter
case.
is not listed, Lordship. On
Service was my mind.
9/11/2020, the matter was, notices were issued. When did you receive the notice?
Somewhere 2020 only, Lordship.
Then what were you doing for such a long time? Hmm? Who is respond number 1? Who is appearing for respond number 1? Minjuma Begum? Nobody.
Nobody.
No, there is a representation. A.K. Azad, M. Rahman, Miss T. Limbu. One number, 14.
I didn't 14.
A.K. Azad, huh? Heard Mr. S.C. Bishwas, learned counsel for the petition. Also heard Mr. S. Bora, learned counsel appearing for the respond number 2, and Mr.
SP Sharma, Lordship.
S.P. Sharma, learned counsel representing the respondent number 3. As a last chance, Professor, the respondents are directed to file their respective responses on or before 27/2/2026. No further opportunity shall be granted to the respondents to file their response in the matter. Also, registry to list this matter again on 9/3/2026 for admissions. We'll finish it up.
I explained this item number 13. Actually, I was given the impression that he will mention the letter. So I came, but I decided my Lordship has approved this much better.
No, I have not. Into ki kurshi.
All the respondents.
None appear for the petitioner. The P. Mohanto, learned counsel is present for respondent or for all the respondents. All the respondents. For the ends of justice, registry to list this matter again after 4 weeks. An advocate of this court, I should not be asking any interest. It's okay. Not yet. Yes, Mr. Gogoi.
The latest instruction I have got, my lord. This year, my lord, it has been proposed.
Huh?
The NSM has proposed for, my lord, giving provident fund to all the employees, including the
Okay.
petitioners.
But
But
as
it
per
will have to
law,
be approved
as
by the
per
central
law,
government. Yes.
as per law,
There is no
APF
cap.
Act, you have to give only 15,000 and less coverage. Now that you have taken that plea, nothing like it, you go ahead.
Yes, but my lord, it is the central government will have to approve it. So by April, we will be able to tell whether they have approved. On our side, we have done it, my lord. For
We'll pass
we will
that.
record it, my lord, let it be posted in April.
But Mr. I am learned counsel for the, no, we are disposing of the matter.
Yes, if they agree in that case, they can account again. But
Huh?
if at all it is not given.
EPF Act to use, Provident Fund Act. But Mr. Ayamat, learned counsel for the petition, also heard Mr. B. Gogoi, learned additional advocate general appearing for the respondents number 1, 2, 3.
Yes, 1,
2, and 3. And Mr. P. K. learned senior counsel representing the respondent number 5. Mr. M. Smith. Respondent number 6. Mr. M. Smith is present, representing, also heard Mr. M. Smith, learned counsel, representing the respondent number 5. Also, the petitioner, by way of instituting the present proceedings, has prayed for registration of the petitioner association. Has prayed for extending the coverage of the employees provident fund to the employees working under the state mission director, National Health Mission. Now it is called National Health Mission.
Yes, sir.
National Health Mission. The petitioner has also prayed for a direction for extending the coverage under the employer's state insurance scheme to the scheme to the employees of NHM. Also, the petitioners at the outset, Mr. I am at learned counsel for the petitioners has submitted that he would not press the prayer made in the petition with regard to extension of coverage under the employer's state insurance scheme to the employees working in the NHM, and would limit his prayer and would only press the present petition to the extent of providing coverage under the employees provident fund scheme to the employee, to the employees working in NHM. Also, Mr. B. Gogoi, learned counsel for the petitioner, by referring to the affidavit filed in the matter, has submitted that the employees working in the National Health Mission and drawing salaries up to the ceiling of up to rupees 15,000 per month have already been brought under the coverage of the Employees Provident Fund scheme. Also, the Act having required the extension of the benefit under the Employees Provident Fund scheme to all employees working in a organization and drawing salaries up to the limit of rupees 15,000, the NHM authorities are found to have complied with the provisions of the Employees Provident Funds and Miscellaneous Provisions Act 1952. Mr. I. Ahmed at this stage has submitted that the said scheme is also required to be extended to all other employees who are also drawing monthly wages above rupees 15,000. Also, responding to the said query, Mr. Gogoi, Learned Additional Advocate General has submitted that a proposal in this connection is already finalized and the same is placed before the central government for its approval. So he submits that in the event the central government approves the said scheme, a said proposal, the benefit of the benefit under the Employees Provident Fund scheme would also be extended to other employees who are presently drawing their wages above rupees 15,000. So, in view of the said developments, Mr. Ahmed submits that the present writ petition be closed with liberty to the petitioners, to the petitioner to file a fresh writ petition in the event the proposal now under consideration by the central government for extension of the benefits under the Employees Providence Fund scheme to all employees drawing salaries above 15,000 per month working in the National Health Mission is not taken to its logical conclusion. In view of the said submissions made by the Learned Counsel for the parties, this court is of the considered view that no further live issue arises for consideration in the present writ petition, and accordingly, the present writ petition stands closed. It is provided that the petitioner would be at liberty to institute fresh proceedings with regard to the coverage of the EPF benefits to persons drawing salaries above 15,000 rupees working in the NHM organization, provide in the event the proposal submitted by the NHM authorities, NHM Assam authorities to the central government is not favorably considered.
Deeply.
Have you filed a contempt? Have you filed a?
Lordship, can you adjourn the matter for the Lordship? My learned counsel is not physically well, Lordship. That's why.
Okay, you just have an instruction. We'll not trouble him here. Why should we trouble him? You ask from him whether MSCT case was filed in this.
Lordship, I'm not completely aware
You
about
ask
this
your,
matter. Yes,
he's not that ill that he can take up phone calls. He can take up phone calls.
Yes, Lordship.
Ask him. Come back.
Sir, Lordship. Absolutely.
My lord, I am appearing on behalf of respondent number 3.
Yes.
We have filed an affidavit in reply. Lord.
It would mention more, it did not mention more. Gauhati just said. None appears for the petitioner on call. Oh, no, like it is second round of. Madam, what are you waiting for?
2021.
Is the respondent counsel available?
2021 and 22.
That premium land settlement.
No, that's cancellation of my.
You got the land by way of a premium, that settlement given 10 years.
10 years, yes.
But you had sold out the land before.
I bought a land from a person who
Before 10.
A lot of.
That's okay, please. Mr. Bachcha, you are ready?
Yes, yes.
Yes.
So, Lordship, what had happened is that a piece of land was settled with one Messrs. Tea Leaf Growers.
Was settled with?
One Messrs. Tea Leaf Growers and Manufacturing Private Limited in the year 2000. And thereafter, out of which they sold about 5 bighas to the petitioner in 2024. the petitioner thereafter transferred 3 bighas out of the 5 bighas to individual persons with due permission of the deputy commissioner. I got permission from the deputy commissioner, GMD, everything, all revenue, everything.
Tea growers was settled with 20 bighas of land.
If not, give me the second one. Dalimi. Yes, if Lordship takes up the other one. Dominancy, this item number? Huh? Item number 22. It's the same, absolutely same.
Huh. The land that was settled with tea growers was 20 bighas, 7 lessas.
Yes.
Covered by DAG number 704.
Yes.
And this settlement occasioned when?
This settlement was in 2000. Then out of this, 5 bighas was transferred to Pawan Kumar Jalan in 2024.
5 bighas transferred?
To Pawan Kumar Jalan in 2004.
That is petitioner in item number 20.
20. Then Pawan Kumar thereafter transferred aforesaid 5 bighas to the petitioner herein.
Item number?
Item 22.
22.
Yes.
Damayanti Das.
Damayanti Das.
Damayanti Das was transferred?
And to petitioner and 7 others, 5 bighas of land was
And what is this Sabitri Talukdar?
This she is also one of them.
One of them. They were transferred land by PK Jalan.
PK Jalan.
So PK Jalan transferred to Damayanti Das how much?
She about 5 bighas. And 7 others. Lordship, it's not 5 bighas, it's less actually.
It's less because 5 bighas is what was transferred
to. Total. Lordship, this the 1 katha 5 lasas. The Damayanti Das was transferred 1 katha 5 lasas. With due permission.
1 katha
5 lasas.
5 lesa. And Savitri?
Savitri was transferred. Savitri was transferred also 5 kathas 1 lasas.
1 katha 5 lesa.
1 katha 5 lasas. All of them were transferred.
Okay.
So now this was transferred with the permission of the deputy commissioner and GMDA. Thereafter, the petitioner wanted to apply for mutation. So when petitioner wanted to apply for mutation, she was denied mutation.
That means Pawan Jalan had transferred all the 5 bighas that was given to him.
Yes, yes.
Then what happened?
And then what had happened when they found, when they went to the, even the name of Pawan Jalan was struck off. So on inquiry, they they told them there was a circular issued by the additional chief secretary.
When was this transfer from Pawan Kumar Jamalan to Damayanti occasion?
That was Lordship in 21st December 2005.
And also to Savitri, same
Yes,
day.
around the same time, 2000 December 2005. Now on 5/12/2006, a circular was issued. They say because of the circular, we cannot transfer.
But the transfer still took place.
Transfer took place prior to the circular.
Oh, sorry. This is after 1 year.
1 year. Then Lordship will come to page 45, Annexure 8. I am direct to the circular by the additional chief secretary, Government of Assam. I am directed to inform you.
Page, madam, page?
Page 45.
45?
In 22. I am directed to inform you that the government had settled land with various organizations, individuals raising premium through the state, throughout the state. The land man ratio in the state is very unfavorable, and compared to the population of the state, the land mass fit for habitation and agriculture is very meager. Government has also been settling land on annual lease and also converting the annual lease to periodic lease from time to time on realization of very nominal amount of premium, which is to the extent of rupees 20 only in case of agricultural land. In case of direct settlement of land towards the areas in premium realized by the government is also on concessional basis, as so as to give the beneficiary a benefit of the land title to the poor occupiers. The objective of such settlement and conversion is to provide land title and legal rights to the landless people residing on those lands, so that they can also take loan, etc., for housing, building, agriculture, and allied activities. But unfortunately, it's seen that in many areas, after getting settlement or conversion of a plot of land, some people resort to selling of the same to to some real estate dealers. It is also it's also not in tune with the spirit of the government objectives. It is not the desire of the government that the land should concentrate in the hands of few individuals who can create problems in time to come by, raising land prices beyond the reach of common man. Therefore, it has been decided by the government that the land settled or converted to periodic lease on realization of premium in the process already stated above shall not be transferred by way of sale, mortgage, lease, gift, etc. for the next 10 years from the date of issue of settlement order or from the date of taking over some possession whichsoever is later. This shall also be applicable in cases of an attorney exercising his her powers of transfer of a plot of land nominated by the concerned landholder. Now this is it. The task is this. Now by this, so they said that it was settled only in 2000. He couldn't have transferred in 2005, giving a retrospective effect to this circular.
But they have added a line there. This will also be applicable to all settlements made earlier which have not completed 10 years period. Page 46.
Yes, correct. Lordship, they added this. And this, as my respectful submission is incorrect, they cannot give retrospective effect. That too also by administrative circular. This is not the law. This is an administrative circular. So on basis of this, they have not given me my mutation. But the permission is when I purchased the land. This circular was not in effect. Now you are putting me in a position.
What do you say from the point of view of PK Jalan?
Lordship?
Same PK Jalan and the other
Everything.
petitioners are the same.
Same. Everything is same. And then, Lordship, in one matter, in one such cases, we had approached this honorable court earlier also. And the honorable court passed an order at page 49, annexure 9, Lordship, after hearing, at page 14, what are you reading? The month is 49. Lordship will find all the submissions are there, and then Lordship will come.
Same ground.
Same. And
order.
Court says, and now Lordship, they filed an affidavit, for which they have brought forward, I have to brought in a settlement, amend the settlement rules. Settlement rules have been amended, and they have also issued another government circular, which is at page 73.
73.
Consequent upon the resolution by the Council of Ministers of the Cabinet, the government of Assam is pleased to accord approval for omission of for the following land policy. After settlement of land to a landless indigenous person mentioned above, the settlement holder shall have no right to transfer this land for a period of 15 years from the date of settlement. Such conditions shall be incorporated.
But this will not have a retrospective effect.
This doesn't have a retrospective. Even the next Lordship will find Annexure 2, page 72, by which the amendment of the settlement rules, chapter 1, section 1 of the Assam Land Revenue Regulation, referred to as the rules, was published in the Assam Gazette.
But again, this will also be of no effect because this is coming to
No,
force
this
only
is not. This is not
April.
retrospective. So in this case, Lordship, they cannot give a retrospective effect. That too also by an administrative circular. I can place a decision for your Lordship, which I mean I don't need, but
still, ma'am.
Still.
These are new matters for me. Only 2 years that I've been able to handle this.
2022 SCC online Supreme Court. Lordship will look at good. I'll take Lordship straight away to paragraph 30.
Paragraph?
Paragraph 30.
30.
30. The power to make retrospective legislations, enabling the legislature to obliterate an amending act completely and restore law as it existed before the amending act. But at the same time, administrative executive orders or circulars, as the case may be, in absence of any legislative competence, cannot be made applicable with retrospective effect. Only law could be made retrospectively. This is so. This really settles my position further. So, in view of this, my respectful prayer is that the petitioner's land should be mutated.
And the mutation which has been cancelled in respect of
Pawan Kumar should be restored.
Yes.
And what we have stated in our affidavit, that earlier in 2006 notification, there was the ceiling of 10 years that they cannot transfer.
No. These transactions that are involved here have all occasion before that notification came into being.
But it says that Lordship has read the line that prior to that, the
No,
10 years.
how can you now impose a condition, which condition is not there in the settlement order? When that settlement was made with Tea Leaf and Growers Manufacturing Limited, you have not projected that there was a condition incorporated therein that for the purpose of X number of years, you cannot retransfer this land.
But for that matter, I have to consult 1989 land policy.
Because we have a decision here of the Honorable Court.
Yes.
Coordinate bench that is binding on me.
Right now, the law is there is a amendment
That
of
law
Rule
you have not
26A.
given it a retrospective effect.
Yes.
Say, I could have understood a situation wherein the land, say a law has come in that you cannot transfer before 10 years. That transfer is not given that is not having a retrospective effect. Say, tea growers have not sold the land till this notification had come into being. They propose to sell it after the notification has come into being. Then this notification will have full force because on the date they submit the application for permission to transfer, the bar as now introduced by the Act, rules or the circular will come into being. Now, when they had sought to transfer this land, there was no bar. There was no bar.
No bar, but that page 46. That page 46 of the writ petition.
That is wishful thinking. That is wishful thinking. You cannot by this say, because if this transaction had not happened before 6/12/2026, 2006, maybe even this line would have had an effect in preventing or in not granting permission to them.
May I put it another way, madam? For whatever reason it was not done. But law as it stands today, there is no embargo for them for getting that relief because of amendment to our settlement rules to 26A.
See, only what we can do here is we can follow the decision of this court, direct you that the transaction having taken place prior to even 6/12, others are not even coming in. Prior to 6/12/2026, 2006, the same being not a condition imposed while making a settlement with tea growers or something,
Yes.
the cancellation of the mutation in respect of item number 20, petition in item number 20 may not be sustainable. Set aside. Now he having mutated himself, the mutation standing, he is also in a position to sell because this condition is not being applied at that point of time. If the sale to the petitioners in 22 and 21 and 22 had occasion before 6/12/2006, then they will have to be given their mutation. And that mutation can occasion only today. You can't give a retrospective mutation. It can occasion only today. But we pass that order. Anything more, madam?
I think that's Lordship.
You need not be here. I'll pass the order in the second half, 2 o'clock.
She'll be here, ma'am. Lordship.
She'll be. You also.
I will be here.
2000, huh?
My lord, here in these cases, we have granted them, my lord, license fee rebate as well as extension for 10 months. They might not have any grievance now, my lord.
Lordship, we have no subsisting.
Ms. B. Chaudhary heard Ms. B. Chaudhary, learned counsel for the petitioner, also heard Mr. B. K. Das, learned standing counsel, railways. Mr. B. K. Das, learned counsel on instructions has submitted that the petitioners in the matter, in the above noted writ petition, have been given a rebate with regard to the license fee as well as an extension for further period of 10 months with
10
effect from
My lord, 2000, my lord, that
That's
March.
during that COVID period, Lordship, Dias period.
No, it will go until when?
Yes. No, they're already over.
Have also given
During the effective
extension of
COVID period.
10 months. Full stop. Which period is also now
Over.
Full stop. In view of the above submissions, in view of the above, full stop. They said submission made by Mr. B. K. Das is not objected to by Ms. B. Chaudhary, learned counsel for the petitioner, who further submits that no further grievance exists with regard further submits that the petitioners have got no further grievance in the matter. So, in view of the above submissions made by the learned counsel for the parties, and there being no live issue and the grievance of the petitioner having been redressed by the respondents, the issues arising in the present writ petition has been rendered infructuous. So, in view of the above, the above noted writ petition stands dismissed on having become infructuous.
Both the cases, my lord. Obliged.
17-18.
17-18.
Great.
Have you filed
Yes, your lordship.
filed an application MSCT case?
Yes, your lordship. They have already.
What is your name? Akan.
Akan.
And Mr.
May I please,
Das, you are appearing?
Lordship, before passing order, I would like to submit one thing, your lordship. As per the notification and according to the order of coordinate bench, your lordship, if your lordship will find for a movement, paragraph number 19, your lordship, of Monisha case, your lordship. Here, lordship, honorable coordinate bench has held that the some cases regarding the city, your lordship, that has been already excluded. That has been already excluded by modifying the notification.
No,
Yes,
no. What is the modification?
Yes, lordship.
Sound दिया सुना था
Last order to.
कॉपी है दिया
It is effect. Top of bottom, your lordship, if your lordship will find the government of Assam is pleased to
No,
exclude.
this is the clarification.
Yes, your lordship.
Now what they say is that
Hit and run and third party within court, your lordship, not traveling in vehicle.
you have not got it. We have dealt with this in our order. It says
In this case, your lordship, it is
it
the.
says all vehicular accidents excluded from 2014.
Yes, lordship.
2014 says vehicular accident in a public place, you are entitled to an ex gratia compensation. This court said no, because you have a better option in a MSCT case. Then 31/10/2003 has come in. 2003 says all vehicular accidents excluded.
Excluded.
So now for a vehicular accident, you are not entitled to any ex gratia compensation, but for cases where except hit and run and third party not traveling in the vehicle. So a person not traveling in the vehicle
Yes.
and not a hit and run case, they will be entitled to a compensation. Now, come to your case.
Here, in this case, your lordship petitioner husband had expired due to.
Means that what they are saying is that if an adequate compensation is not permissible to be given by the by filing a case before the MSCT case, hit and run I think is 50,000.
Now it is
50,000, Mr. Decca?
Now it is become
Hit and run cases.
No idea.
No idea.
Lordship, as per 2019 amendment, it become 2 lakhs, your lordship.
2 lakhs. So that case, if the identifier of the vehicle was found, then it could have been more. And where is your FIR here?
FIR at page 23, your lordship. This was not traveling in vehicle.
No, it will not be because this is prior to 2023. And this prescription will not, because you have got a compensation from the,
Lordship.
you have agreed to that. Then
And lordship, as per para 15, your lordship, your coordinate just has held that the.
my Lord Justice Surana's.
Yes, lordship. Paragraph number 15, your lordship. In the case of Shashi Sharma Chopra, the Supreme Court of India, I have him. Your lordship, paragraph number 15, in this case, your lordship, the Shashi Sharma Chopra, the Supreme Court of India held that a claim based on contract cannot have any correlation.
Oh, we'll ignore that paragraph.
My lord,
Yes, Mr. Das.
same judgment I'm relying on, Monisha Khatun.
And the Monisha judgment already, they have preferred an appeal. That appeal become infructuous because they have already got the relief. Therefore,
We are
divisional
not
officer
concerned. I have
has not entertained.
only thing you cannot hold it against me. I've been passing consistently this all. Dismissed.
I'm so obliged, your lordship.
You have your MACT case number?
No.
15 to.
But we record that MACT case was filed and compensation granted.
Lordship.
15 to.
लिख ले वो ना बेटा.
I'm so obliged, your lordship.
15 to.
15.
15 to be 9 again.
That's same about it.
More or less.
Have you informed the other side? Pension. Mr. Ghosh. A prayer is made on behalf of Mr. A.Y. Chaudhary, learned counsel for the petitioner for an adjournment in the matter on the ground of?
Medical ground.
On the ground that he is presently indisposed. Also, prayer is not objected to by Mr. A.K. Ghosh, learned counsel for the petition. For the learned standing counsel, PNRD department, appearing for the respondents. Accordingly, registry to list this case again on 5/3/2026.
Please, your lordship.
Yes, why have you not filed an
Lordship,
affidavit?
we have submitted the affidavit to the department for writing. Lordship, it will require 2 weeks time to file our.
No, give me a date when you are filing it.
Lordship, by 28th of this February.
That is more than 2 weeks.
No, Lordship, today is 10.
File it by
Lordship, it
20th.
will come from Dibrugarh, Lordship.
Dibrugarh is not in Moon or Mars. There,
Lordship.
23rd.
Lordship.
Mr.
K. Jain, Lordship.
K. Jain, learned counsel for the learned counsel appearing for the
Lordship, for
learned counsel representing Mr. S.C. Learned counsel appearing on behalf of Mr. S.C. Cal, learned standing counsel
CGST.
CGST, submits that The affidavit on behalf of the respondents represented by him would invariably be filed on or before 24/2/2026. Petitioner is at liberty to file a rejoinder thereto on or before 6/3/2026. Registry to list this matter again on 11/3/2026. It is provided that in the event the affidavits are not filed by the respondents on or before 24/2/2026, no further opportunity to file the said affidavit would be granted to the respondents. Registry to list this matter, Colonel Iman? 11/3.
Much obliged.
Much obliged.
Where is Ms. M. Bachaji? Mr. Das, where is Mr. M. Bachaji? Huh? Can you inform her? Let her.
Lordship, may I pass over for that time being?
Today it may not be possible. Any matters. Where is Mr. Soikia?
Not.
You are 40?
I'm 48. Petitioner.
Petitioner. Your case is that no ancestor of the private respondent was a patadar in the land.
Number 6.
Yes. How do you say that your
Sir, RC Secretary, sir, is just 1 minute, sir.
My senior legs in code number 9, Mercy.
timing?
Debug.
In the next round only.
Lordship, this matter may be taken up after some time, Lordship.
Your 40 petitioner. The additional affidavit has come.
Yes. Just two or three documents, madam. It's documents of National Highway Authority of India.
You are appearing for
Petition.
petition. And who is for the national highway? Mr. Decca, you are appearing for whom?
Yes, item number 28.
Earlier, Mr. Decker was appearing for, in this case.
Okay, okay. Ms. Bora, have you got, Madam Bora, have you got this additional affidavit?
Additional affidavit?
Some Das has taken it, 7/2/2026, on 7 itself.
550. It's three documents. This is.
No, but she may have to have her instructions on.
The case coming, Lordship. He has
Who?
been engaged. This right here. He has been engaged as a senior counsel. He is coming.
Advocate General Desoika. I think I passed some orders.
Yes, yes.
It's with regard to that construction.
Yes. The protected building.
Oh, you misrepresent. You misdirected me. Now, what is the situation of your debarment?
That is state.
That is state. You're continuing.
Yes.
But only in the meantime, I have received your information. But my client have given me information, even though NHA authority has been duly intimated regarding the stay order from the website.
They have not removed it.
They have not.
Maybe they are expecting that today would be the day when it will be continued. Okay, let Mr. Soikia be here. No, if you want to take a adjournment with regard to this additional affidavit, then we'll not take it up. We'll take it up together for final disposal.
Saturday.
Saturday, sir. As is Tuesday. Saturday, they have filed.
That is what I'm saying. If you want to take, otherwise we'll continue with the hearing.
CGC, they have got today.
Oh, CGC is nothing here. You are the man.
Yes, that is true also.
Anyway, Mr. Soikia is on his way. Let us hear him also. If he says he's ready with the argument, we can proceed with him. What is your basic grievance?
Well, I am the safety consultant. I am the enlisted.
You are a safety consultant, yes. Some structure fell down.
Yes.
Right?
One girder has fallen down from the bridge and one person has unfortunately expired. So my contention is that I am liable for drawing at the preliminary stage, not thereafter.
You are the one who would vet the structure.
Yes.
That's your
at the stage of DPR.
DPR. Now, when the work is going on,
yes,
you have got no role.
I have not got no role.
Who will take care of the safety requirements when the work is on?
Authorities engineer, the contractor, they are liable. That's why I have filed this additional affidavit.
Okay, well,
It's
just
there.
show me that.
Yes.
That's the issue.
That's the only issue. 556 page. There is additional, it's their document only. Five, 556 Annex 9. I'm sorry, my lord, my voice is little bit.
Take your thing. I'm reading it.
Page 557, Roman 4.
Into
557, Roman 4. Oh,
ACD.
Okay.
Roman
These
4.
are works which will come within your purview.
Yes.
Okay.
Then safety during construction, next page 558.
Don't exercise. Don't exert your voice. Again, DPR stage,
Yes.
design stage.
Yes, at design stage. Now 560 is another.
Yes, Mr. Soikia. Mr. Soikia.
Lordship,
we-
whether this
waiting
matter is
for you.
still alive or not, I am little.
No. It's alive because there is a stay order only. So what has happened is that they have filed an additional affidavit.
Lordship.
And they have brought in 3 circulars, which according to the learned counsel for the petitioner, delineates their role. Because he's a safety consultant, this accident occasioned during the
execution of the work.
So his contention is that I'm not responsible for that. And in support of that, he has filed an additional affidavit today.
Definitely, Lordship.
You
Then
will
we'll
have to just go through that.
go through and we'll like to respond to that.
He'll have to go through. When?
After 3 weeks.
No. Nowadays, 3 weeks gone. Date.
Gone. Days.
Date.
3 days.
No.
2 days.
3 weeks, you give me a date when it's comfortable to you.
Just 1 second, Lordship.
Because your free is to
Yes,
be
2026.
20, you are free on that day. 26th of
this month.
This month. Okay, done. But Mr. A. Learned Counsel.
Or if very convenient, Lordship, then let it be on 10th of March.
Done. Any problem? Also heard Mr. Deka, you are appearing the next matter?
Yes.
Also heard Mr. P.S. Deka, Learned Counsel for the petitioner in WPC number 4833/2025. Mr. 8 Hor, in WPC number 3647. Also heard Mr. D. Saikia, learned senior counsel, appearing on behalf of the NHIDCL authorities in the above noted petitions. Also, Mr. 8 Hor, learned counsel for the petitioner in WPC number 3647/2025 has brought on record an additional affidavit filed by the petitioner today. Also, Mr. Soikia, Ms. Bora, learned counsel, assisting Mr. D. Soikia, learned senior counsel, appearing for the NHIDCL authority, submits that they be granted a 3 weeks time to respond to the contentions and documents brought on record by the petitioner through the additional affidavit filed today. Also, as agreed to by the learned counsel for the prayer accepted, as agreed to by the learned counsel for the parties, registry to list this matter again on 10/3/2026. Also, before the next date of listing, the NHIDCL authorities shall bring on record their response to the affidavit, additional affidavit filed today by the petitioner in WPC number 3647/2025, ipso advice.
We have not received the additional copies.
I have given.
No, they have not received it, so they are saying.
No, it was not given. It was given, but to some other clerk.
So we'll get a fresh copy from them.
Madam Bora will ensure.
Interim order.
Interim orders passed. In both cases are.
In both cases.
Interim orders passed earlier to continue till the next date of listing.
Deeply appraised. 10th of March.
My friend has another prayer that from the website of.
We'll not do that because it's only a stay. If they are creating a problem for you because they are not allowing you to apply in other 10, then it's a problem.
That is what is happening.
Mr. Saikia, we have stayed the termination, but he says that you are not complying with that. Kindly have.
We'll instruct accordingly.
Mr. Saikia will take care of that.
Highly
Obliged. Lordship, in this case, Lordship, I am led by Mr. K. N. Chaudhary, Senior Counsel. He is on his leg. May I pray for some time, Lordship? We have taken up to some time.
Others are ready?
Lordship.
We can take up the matter for final disposal?
Yes, Lordship. At 2, Lordship.
I can't say that.
Because my application under section 17B is also pending for final adjudication.
Now it is who should be the one.
That is the.
Whether it is respondent number 3 or the petition.
Lordship.
What is your stand on that?
Lordship, this BTA and the disclosure letter was never put to the labor court during the argument. In the order dated passed in the year 2014, my lord, there is no utterance of the business transfer agreement which took place between the petitioner and the respondent number 3, my lord.
Now who is in place? Petitioner or you?
Lordship, we are in place, but we are also under liquidation, my lord. So even if this honorable court holds that the respondent number 3 is liable to
on
pay.
the date, the claim of the persons before who has raised the reference.
Lordship.
The day when the claim therein had been generated.
Lordship, till on that day, no BTA was entered into.
No, that day it was he who was in.
Lordship.
In place.
Lordship. When the reference was made.
Reference was made.
Lordship.
After the reference was made, the transfer took place.
Lordship.
From the petitioner
to respondent number 3. Lordship.
So now the question is, who would be liable?
Yes, Lordship.
In your transfer agreement,
Lordship,
is there any clause pertaining to this? Because this was the existing dispute.
Lordship.
Faced by it.
There is one.
Was it also transferred to you?
Lordship, there is one, but Lordship, there is 2 clauses are there which I need to place before your Lordship. Your Lordship has to decide that. And one more question is that, Lordship, while deciding before the labor court.
The challenge of the petitioner is, I don't think so, very serious challenge to the findings of the final award. It is to who would have to bear the burden.
Lordship, but the petitioner has conducted the case before the Labour Court. It was not
Maybe.
the respondent number.
Maybe.
The petitioner did not place the BTA and the disclosure letter before the Honorable Labour Court, my lord. No utterance of the business transfer.
Now you are before us.
I am respondent number 3, Lordship.
You are before us.
Lordship.
Now in this proceeding, can't we do that?
Lordship may adjudicate that. Let me place the clauses before your Lordship of the business transfer agreement. There are 8 clauses which I need to place before your Lordship.
Now, if we hold that it is not you, but he who is responsible,
Lordship.
you have not taken that plea before the
Lordship.
What happened, Lordship, that what I want to place, Lordship, after the BTA was executed, Lordship, my petitioner stopped appearing before the Labour Court. It was rather them who appeared before the Labour Court. That the Lordship will find from the lower court record, Lordship. What happened? They have placed all in the evidence, they have placed their own record, the service and all of respondent number 3.
Means you mean to say after the BTA,
Yeah, we
the name did not change, but it is they
Them,
who took
yes,
over.
yes, yes. Because what happened?
What is the name of the firm?
Mine is Vidyut Metallics and they are
Supermax.
And Vidyut Metallic transferred their industry to
As a going
own
concern,
company.
as a going concern to respondent number.
Lordship will may peruse page 72 for a moment, Lordship.
72.
Lordship. It starts from Lordship.
72.
Is schedule 4, Lordship. Second clause, contingent litigation liabilities. And serial number 72 of that schedule, Lordship, at page Lordship 74. Serial 72, application number 6 of 09, CRU, certain.
This is the projected cost, 14 lakhs.
Lordship, yes, Lordship.
Contingent projected.
Lordship, it was transferred. And regarding, Lordship, what my landed friend has submitted, the proceeding was going on during the BTA. Lordship may peruse 154, Lordship. For a moment, Lordship. There is, I have next reference proceeding disposed of by the landed Labour Court of Thane, Lordship, wherein, Lordship, the Labour Court has hold that it is them who is to pay the benefit. It has not been challenged.
That was in respect of a separate case, Lordship.
No, it's the same BTA was taken into consideration, Lordship. Page 154, Lordship.
Okay, how do you show that he was appearing? Not you.
That the lower court record will be required, Lordship.
The record side.
Before that, Lordship may see one clause.
Well, I'm coming.
Lordship.
Not please. Yes, where do I get it?
Lordship, if your Lordship takes up the exhibited document, Lordship. Exhibit M, Lordship will find, Lordship, that document relates to metallics, Supermax, Lordship. And the agreement with the employees and all. They how I can place this document before the Labour Court? These are their
Exhibit.
specifically, Lordship may find exhibit M, Lordship.
M,
Lordship.
1, 2, 3, 4. That is
Document, Lordship. All Supermax document, Lordship will see. These are all their document.
Have you taken a specific plea to that effect in the writ petition?
That plea, Lordship, I have not taken, but because no, I've taken the plea that they were appearing. That plea I've taken, Lordship. That plea I've taken, Lordship. That they were appearing.
M,
Lordship.
ALM. Supermax.
Lordship. That plea I've taken. That they
Who
were,
were the witnesses appearing?
Lordship, a witness appeared, 2 witnesses.
Let's see the deposition.
No,
Mr. Saibala, we are just understanding the issue. We are not.
My lord.
deciding.
Lordship.
In their evidence, have they somewhere brought this fact to the notice?
No.
Nobody.
They have not uttered a single word in this line, Lordship.
No. That
Supermax, that part they have not stated. because Lordship, I have stated in my writ petition, some hostile director who have taken over the company as Supermax Lordship. So because they have that tried to burden the same upon us Lordship. Everything I have stated in the writ petition. This is the reason Lordship, we got notice of the proceeding in the year 17. The award was passed in the year 2014. What happened after we received notice from the learned labor officer, we intimated them the entire fact regarding this PTA and all. Then my learned friend, the union, they approached for execution of the award, implementing them as a party.
That was withdrawn.
That was withdrawn.
Sorry.
Then they filed a 32.
32. They have initially, they have also understood that Supermax is the party. So they have filed an execution petition alleging them, arraigning them, not us. They appeared.
32 to 33.
33 against us, now against us.
Computation of money and
That is now, in the 33 proceeding, they have not added them as a party. We have approached this.
Okay, this will require some hearing.
Lordship.
When? Tell me, give me a date. Let me know.
Only some urgency on the part of my learned friend.
I got it. His case is from whom the money will
Yes,
come.
and 17B. 17B, if we need to pay, then for this reason, this honorable court inclined to dispose of the entire matter.
One more fact is there, Lordship. Anyway, respondent number 3 is under liquidation. Even assuming this honorable court holds that respondent number 3 is liable to pay the amount to the
That will be
employees.
added to your, that will be given to the liquidator. Liquidator will,
Lordship, they have to approach the NCLT under section 65 of the Insolvency Act.
First, we'll have to decide.
Lordship.
Thereafter only they'll.
Lordship.
one more thing is, I am an workman. So basically, I'm before the Lordship contesting the writ petition. I will pray the Lordship to decide my legal entitlement. So
That's it. Your legal entitlement would be whether the award, that is not under, literally not under serious
Exactly.
challenge. The only challenge by the petitioner is that he is not liable, Supermax is liable. Supermax has not come up against that award. Right? So your case, the only direction we can pass, provided we don't find anything further illegal in the award, is that whether Supermax will pay or Biddut will pay.
Yes.
That's it.
Yes.
Now, if Biddut pays, there is no problem. You can file an execution, you can file anything, you can get it. But if it is again the Supermax, problem would be it's under liquidation, IBC. What do you call that?
Moratorium has been issued against
No, that
Insolvency.
resolution professional.
resolution
IPR.
professional is already there.
IRP.
So you will have to go before the concern under the IBC, you will have to take
Before the
proceedings
bench, my lord. Before
to
the
the
NCLT.
bank, the creditor bank, you will have to approach them. They will have to accept, okay, once we pass an order, maybe that will become like a decree, that will be liable to be executed.
no, I am whatever what I am trying to get Lordship, that certain legal issues are. Suppose that is why I am telling that my legal entitlement. Suppose that in a labor court proceeding, whatever the documents produced, it is an evidence proof. The document which they are relying here before your Lordship was never proved, never proven.
No, that's one fact. We'll have to see first, who is the person on the date responsible for your liabilities. That's all. If we find it is to be the petitioner, then the petitioner pays, there is no problem for you. But again, if we hold it to be Supermax, you will have a further hurdle to cross. Because we will not be in a position because of the IBC provisions. We will not be in a position to pass any order. When?
Practically.
Tuesday, Thursday.
17th, my lord, Tuesday.
Sir, 17th, Lordship.
As agreed to by the learned council.
17th, Lordship.
7th be 19th, not beyond that.
Lordship, except 17th, Lordship.
19th.
My lord.
As agreed to by the learned council for the parties. Registered to list this matter again on 19 to 2025 for admissions. Full stop.
Can it be? Thank you.
Come back to me.
Can it be at 2, my lord?
This matter, as the pleadings in the matter has been completed and the relevant trial court records have been, and the records from the tribunal has been received, an endeavor would be made to dispose of the matter on the next date of it.
Can it be at 2 p.m. on 19th?
You make a mention, no?
Lordship,
For 2 p.m.
My lord.
Just make a mention.
Lordship.
Inform the other side.
Lordship. Deeply ordered.
Eight, Lordship, 8-1, Lordship directed us to file our written arguments, my lord. My petitioner size, they have already submitted, my lord, on 19th-1. So today, my lord, I am submitting that written argument, my lord, from the respondents, my lord.
That period.
My lord.
How?
So only submission is this. I am on one point. My lord, they are relying on the judgment of 2012. Just
Forget the judgment.
but only thing is this, my lord, I am relying on one point. That is, my lord, what I am trying to say is there's no nexus between that leap period and the disease and the element which is now, my lord, demonstrating before this honorable court.
He was on
leave.
He was on leave.
On leave, yes. But
He did
only
not
for treatment of his wife.
He did not come back.
Yes, he didn't come back.
So you declared him to be a deserter.
My lord.
Then he was arrested and brought.
Yes.
You withdrew the order of desertion.
My lord.
Deserter order you withdrew.
Yes, my lord.
Now you then sent him to your own composite medical
My lord.
hospital. When he was there, he
Yes.
was treated.
Yes, my lord.
And these records are with you.
Yes,
Then he was reinstated,
my lord.
permitted to work.
My lord.
Now, while he was working,
Yes.
you again institute a proceeding against him.
Yes,
Same allegation,
yes,
unauthorized absence.
yes.
Now, this was a vital document, which now is projected by the petitioner to be the reason why he was not working.
Yes.
This document was with you because you had
Yes,
deported him.
it's on record, my lord.
No. Before the inquiry, this medical certificate
Yes.
was a document to the knowledge of the disciplinary authority.
Yes.
Why was that not taken into consideration of finding out?
That,
That in spite of this,
yes,
that this will not show
Yes.
that the absence was not willful.
but that document lordship can take note of because the document is of 2004, 2005. In 2005 itself, my lord, I found in record that he was declared to be fit. From 2005 to 2014, he
No.
continued to work. Yes, well, it's on record. Lordship kindly perused.
Here the charge is
Yes.
he was absent from
From, my lord,
Date?
from 4/6 to 2014 to 3/7, 2014, 15. If I'm not wrong.
4/6 to 3/7/2014,
Yes,
right?
yes, my lord.
4/6 to 3/7.
Yes, it was almost after 9 years, my lord, he was declared.
Where is
fit.
your that medical examination certificate, Mr. Gogoi?
That's page 14, your lordship, annexure 1.
1/4
1/4. Medical certificate for leave extension leave.
of your writ petition.
Writ petition, lordship. And the discharge slip is at page 15, your lordship.
It's a- I only,
8 to 8.
five,
I don't know. I don't know.
5/4.
4, I don't know.
তাৰপিছতো নাদপো নাই।
That is after the show cause was given to you.
Show cause was
22-1.
show cause was issued on annexure 2, page 16, your lordship.
Hmm.
2nd January 2015.
And your admission is thereafter.
Thereafter.
10/3/2015 to 10/4/2015.
10/3/15, 10/4/15. Show cause was given after the admission, lordship.
Where is your statement with regard to that treatment received by you?
Statement of representation is para 5 and para 6, Your Lordship.
Now, where is the material to show that this ailment of yours did not permit you to join in service? What is meant by mild cerebral atrophy?
It's an early stage of gradual reduction in the brain tissue volume, Your Lordship.
But that will not be of a situation wherein you are not in a position to inform.
Since the petitioner was on leave duty, Your Lordship, he reported back to the
You went on leave from 4/6 to 3/7.
3/7.
Thereafter, you did not come back.
We returned back, but at the gate, we were asked not to come back. Not to enter.
But the charge is that you have.
At para 5, we have categorically stated, Your Lordship, para 5.
But that has got no substance because you went back. Where were you?
You were supposed
This is impossible. In an armed force, this is impossible. This plea of yours is impossible. Because an armed force personnel will never be allowed to go out at night. Something happens to him. The entire unit will be in trouble. So they will not permit. If he had reported on 4/7, this is an after. Where did you go after 4/7?
We went back to the Gauhati, Your Lordship, so they could report.
Where was your this center?
My center was at
No, in fact, my lord, he had reported because we have taken a stand. We have said in our affidavit that he had reported. He was supposed to report in the evening roll call of third. He turned up on fourth. Yes, fourth, not fifth, fourth, my lord, at 11 p.m. in the night. That's why he was coming the next day on fifth, but he didn't come back. That's our case.
Okay, then what happened?
Thereafter, the petitioner was arrested on 10/3/2015.
However, the petitioner could last remember that he had a serious headache and he was unable to remember anything further during the period from 4/7/2015 to sometime in April 2015. Now, what treatment did you undergo? How far is your house from the camp?
This group center is also located in this Normal, Your Lordship.
Normal. You are in Gauhati.
Yes, and he is
from Gauhati to Normal. It's not far.
Yes, it's not far.
Then why you nor your family members reported?
Family members reported back.
Where is that letter?
Letter.
So where is the material to show that it was because of this attention deficit syndrome that you had not reported back to the duties, nor your family had informed this fact to the authorities, nor you got yourself admitted in the composite hospital?
We got composite, we got admitted, and thereafter treatment was done.
No, composite hospital admitting is in 2015.
15.
That is after you were arrested by the police, taken there, they sent you to the hospital. Now this, between this April, 07-2014 till March, what was the treatment received?
Record of shaking interest.
So, Digari, be careful. Now it is Uguri Square.
Malad, I was just going through, I found a case, Malad, Rakesh Kumar Hariwal. Hariwal case is, Malad, the person with disability, especially this kind of disabilities, Malad.
Show me that this is a disability and you have been recognized as a disabled person.
Malad, that act, I'm going through the judgment, Malad. I was just researching last night. Hariwal's case, Malad, that section 47 lays out a procedure.
You show me that you had taken this plea that you are a disabled person from July 2014. What treatment was being received by you?
2014.
Or you were having some very pleasant drinks only?
Nowhere in the writ petition, there is a statement.
But my lord, the very fact that
the
they
medical report also indicates that you should not take alcohol.
My lords.
So excessive alcohol consumption is also one of the reasons for this
that
shrinkage of the brain.
That also has to be tested by them. If that is the charge they put on me, then Munna Lal's case.
I am trying to understand it.
My lords.
My thing, I am trying to understand.
My lord, I cannot make this brief better because my lord knows it's a brief of 2015.
No,
and it is passed
my
on to
thing
me.
is from 4/7/2014, what were you doing? I accept that you went there also because Mr. Adigari admits to that. Then on, if you could have gone on 4th, then what happened on 5th? Compulsory retirement with pension.
Yes, pension gratuity.
My lords, from their test, it is admitted that I was undergoing something. I had something. So
No, that had something prevented you from receiving or approaching the authorities in any manner. What is there? Where is that? Because the article of charge number 3 has to be read in the context of 1 and 2. You are seems to be a regularly irregular absentee. Mr. Gugoi?
My lords.
Regularly irregular absentee.
Well, I hold a record. It's from 2004, where he gets Bell's palsy. Their certificate.
Yes. Is there?
Bell's palsy, my lords. Again, Bell's palsy, 2004. There.
Forget that.
And my lord, it is again from there, my lord. 2013, my lord. There's a record. ADS.
ADS means?
Attention deficit, my lord. Syndrome.
Where?
It's their record, my lord. Phul Kumar Das record. It's I hold it's signed by the CRPF authorities, my lords.
What are these records?
These are the records of
the service records.
Yes, my lords. All in history, my lords.
So he has a history.
Yes, my lords. Those flag marks, my lords.
But you were in shape 1 in 2011.
My lords.
Shape 1 still. I don't think so. This is a. Because you say that you had gone with your wife on 4th.
My lords.
So if from 5th you are not in a position to go, there is no statement that even your family was not in a position to inform. Okay. Where is any judgments you want to further rely?
Well, I have given my written argument.
What is that?
That B. Karunakar, I am pressing into service, and this recent judgment, my lords, one judgment was there, my lords. Let it listen.
B. Karunakaran is clearly distinguishable for the fact, they are not here. His specific.
You want Kushan P. Parmar?
Yes, Parmar, 2012.
Parmar and Saudagar.
Yes.
Yes, my lords.
That is clearly.
VM Saudagar.
You also may kindly come to Para, my lord.
This may not.
This is not applicable.
Full force apply.
Yes, it will not apply.
Well, the ratio will apply to me because when I take a plea that I could not attend my duties because
Where is your plea?
Well,
where is your plea before the authorities?
Well, that was known
you
to them.
You produced a witness also.
They charged me. They took me to check up. It was found from their doctors.
No, what I'm trying to say is that where is your plea that this is because of this reason from 4-7? They are not expected to presume a plea. That from 4-7 I've not been there because of this. Finished. Then the honors will shift to them.
Well, honors,
just show me that one line somewhere.
Honors is still on them because they got me checked. They got me checked in their own hospital. They have to act like the Negi's case, my lord, perhaps would come to my rescue a bit, my lord, because they have to prove their case. It's me, my lord, who is suffering from mental atrophy, who is not a.
It is not madness.
It's not madness. It's my brain shrinks.
Shrinks, but where is that? Then but you are still categorized as shape 1.
Yes, yes.
Then. Where is the inquiry report? Inquiry report is on record.
Yes.
We will see. I'm gonna say it was.
Mr. Gugoi.
My lord.
I'm not troubling you today.
My lord.
Giving you one more opportunity.
Yes, my lord.
Come and convince me.
Well, I'll bring the Dhariwal judgment. I'll convince
you do whatever.
Yes, my lord.
But don't go beyond what is there on it.
My lord.
And where do I get his statement in the inquiry?
Statement of witnesses, my lord.
Witnesses and the statement of this,
Yes.
but not in Hindi.
It's in Hindi, my lord. That's difficult.
You will have to convert that.
Yes. The records
You have
are
it?
in Hindi. Yes, I have.
What is the statement? Read.
But he was given enough opportunity to cross-examine, my lord. He declined to cross-examine the
He had
witness.
produced one evidence, witness.
No, he has not. All the 7 witnesses,
He had accepted, my lord, that it is guilt.
he admitted, my lord.
But my lord,
No. I just want to know what is his statement. Where is the inquiry report, Mr. Gogoi?
report to Mulkot Nai. Mulkot Nai, my lord.
So
It is it him, my lord. I don't have it.
I think, well, it is
What
there.
is there? What is his statement? Just read.
I was just trying, well, these are all handwritten, my lord. It's difficult to read also. I find it difficult to read,
Give me the inquiry report and the statements of the.
my lord. I'll get it translated into English, my lord. Yes.
Heard the Lana Council for the parties. Further, heard the Lana Council for the parties at something. So, Mr. Gogoi submits that the matter be taken up on when?
Day after tomorrow, if he can provide
No,
the
no.
English.
That will be difficult for.
Yes.
When can you do? Give me.
There should be
Depends
granted
upon
2 weeks' time.
Praise that be taken up in on 24 to 2026.
But can it be on 26th, my lord?
26, my lord, I have to attend Mizoram, my lord. Sir.
You are not here on 24 and 25.
Yes, my lord.
Let us have it on 23 then.
But because I have my nephew's marriage, my lord, that's why. On 25th.
27?
27th, yes.
27 ahi na pam. Mizoram ahi na pam.
So two.
Second month.
2026 to enable him to make further submissions. Mr. M.R. Adhikari, Learned CGC submits that on the next date of this thing shall place on record the translated copy of the inquiry report as well as the deposition of the witnesses and the petitioners and the petitioner in the inquiry.
My lord. All right, my lord.
For further hearing, registered to list this matter on 2/3/2026 for further hearing.
All right, my lord.
Yes, anything?
So it's not beyond reasonable doubt. There are so many doubts regarding the incident, the time, etc. Their lordship. Although
We are acquitting him.
lordship.
Lordship, after some time, Mr. Borwa is coming, Lordship. He's interested in the matter. Mr. Borwa is coming, Lordship. Yeah, Lordship. Also, in respect to item number 6, Lordship, I have go through it, Lordship. That timing matter, item number 6, Lordship. That particular affidavit was filed by the BTC, Lordship. I have go to the paragraph 3, Lordship. After filing of this case, Lordship, that particular person which was allotted, he was cancelled and it was now entrusted to the nearby one shop, Lordship.
That's what I said.
That is the reason, Lordship. Yes, because, Lordship.
So when we call it up, I think now both have gone.
Lordship, both have gone.
So now the district administration in terms
Now,
of
Lordship,
the public order.
it's a transport subject. That's why, Lordship, our instruction is defined.
I get somebody from BTC also.
BTC, Lordship, Lordship.
Whom have you informed? Ask her to be here.
Lordship.
You are appearing for her.
Yes.
Okay, when she is free, ask her to come. Yes, Mr.
My lord.
What are your instructions?
My lord, that is the problem, my lord. They say that they need, it's an old record, my lord. They need at least some more time, my lord. Means all these hard copies, it was sent somewhere else. All stacked there. Digitization is going, some done, some not done. So they have to take it out from there.
We'll give you. How much time you want, we'll give you. Don't worry.
My lord will indicate this is the last chance. I also don't want to
Mr. Adhar, Standing Counsel, PWD, submits that the respondents represented by him, in spite of best efforts made, have not been able to unearth the records of the petitioner, which were so relied for preparation of the list of master role of work charged employees for a regularization of their services. He submits that a last chance be given to him for furnishing the said records before this court. Registry, a prayer accepted registry to list this matter again on, when you give me a date.
My lord, 2 weeks. My lord's convenience, my lord.
They are not receiving salary.
26 to 2026. No
For
further
further-
adjournment shall be granted in the.
Obliged.
I just want to be sure, that's all. Otherwise, we are ready with you. None appears. Oh. Yes, madam, what has happened?
May it please your lordship, my senior has not come yet, so lordship, please
That we can
kindly
help.
pass over the matter for a day.
Uh, a prayer is made for an adjournment, even for. Prayer is made on behalf of Ms. D. Ghosh, Learned Counsel for the petition for an adjournment in the matter. Full stop. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, registry to list this matter again on 5/3/20.
Thank you, lordship.
None appears for the petitioner. You're for the petitioner, madam?
Lordship, senior counsel is less in court number 1, lordship, so kindly take up this matter after break.
Huh?
Senior counsel is less in court number 1, lordship, so kindly take up this matter after break.
After break. Yes. What is the instruction? Has he filed a
Yes, Lordship.
MSCT case?
No, Lordship, instead of MSCT, we filed a WC compensation act before the Labor Commissioner, and what is still pending before the same court.
Okay. Where is the FIR?
Sorry, I don't have the records, sir.
FI page 14, your lordship, annexure
14, your lordship.
A prayer is made on behalf of Mr. M. Soikia, Learned Counsel for the respondent, for the petition for an accommodation in the matter today. Prayer accepted, registry to list this matter again on Thursday. No further adjournment shall be granted in the matter. Ms. N. Bodle, Learned Standing Counsel. What are you appearing for?
I am for respondent to
For Standing Counsel, Revenue and Disaster Management is present. Will.
yeah, the vehicle is already identified. Means,
Is not there. He's a young guy. I don't want to put it in his shoulder. Thursday.
yes, sir.
By sleep.
Yes, sir.
And Thursday, I'm not adjourning. If he is not here, we are proceeding with the matter. None appears for the petitioner even on second call. Miss
J. Decca on behalf of K. Fukon.
Ms. J. Decca, Learned Counsel, appearing on behalf of Mr. K. Fukon, Learned Counsel for the
Respond number 3, my lord.
respond number 3 and Ms. Ms. Didas, Learned Counsel, appearing for the respondent number 6 is present, are present. So in view of the above, the present petition stands dismissed for non-prosecution.
My senior is election court number 9. Hearing
Can't
going
help
on, Lordship.
So Sukhya is not here. Give me a convenient date.
At 2 o'clock, my lord, because our time is
We have
urgent.
fixed up some other matters.
Today
That's
is
all.
not possible, Lord. Hearing going on, continue.
That's it, fine, can't help it.
Only,
Tomorrow, Lordship.
only what happens.
But Mr. Sukhya,
Only day after tomorrow, my lord.
They are
No, no. Mr. Sukhya, what is the material to show that your forefathers were also a pattada, co-pattada in that land?
My lord.
In your affidavit that you have filed, you have literally supported the case of the petitioner. Now you have filed an additional affidavit saying that it is correction. That correction cannot be done in that manner.
Lord,
You should have filed an IA for amendment.
my lordship, just a minute. My lord, the report of the Latmaldar and the circle officer,
That report,
that is material because, and the Jamamandi also shows.
you are relying on a draft sita, whereas in the main
And Jamamandi
Jamabandi and
also.
the sita, your name is
No,
not
no,
there.
Jamamandi is in my grandfather's name is there. And what they are, the circle officer and the Latmaldar report has found that physically I am there from 100 years ago. And then I am the grandson of Kanduram Bharali. And my father and Parshuram Bharali, their father were two brothers. And it should divide into 4 parts. But the Namdero was granted to the petitioner. He was a minor by 5 years old. This is reflected from the
We will
report.
have it at 2. At 2. Let Mr.
My
Sharma
lord.
also.
Oblige.
Yes, Mr. Ullah, how can we help you here?
Lordship, at the time of filing, there was no tribunal.
Fine.
So at that time, I had this court has jurisdiction, Lordship. So on consideration of the tribunal now, Lordship, my prayer would be my petitioner number 3 and 4 may be struck off, and they may be allowed to file appropriate application, and the limitation be condoned because
The limitation we will not.
because of the peculiar fact, Lordship, as per 129, it must be within 60 days. But when I will go.
Statutory prescription, nobody can, because there is no provision for.
Yes, Lordship.
Even the court cannot extend that limitation.
Lordship, I'm trying to, Lordship, I'm trying to impress upon that at that time it was 60 days and there was no tribunal.
Okay, we'll examine it on a different.
Yes, Lordship.
Your whole case here is pertaining to the manner of conduct of election.
Yes, Lordship.
You have got nothing to, no allegation with regard to the eligibility of the person.
Yes, Lordship.
Child marriage, matriculation, you have nothing.
Yes.
So this is basically something which is leading to the election, issues that have rise, voting,
yes,
cross voting, bogus voting.
Yes.
These are matters per se which will come within the purview of the election tribunal.
Yes, Lordship.
So when the election tribunal was constituted, you should have withdrawn this application and filed it there.
No, Lordship. Till today,
Not
on the last
constituted.
day also, they have not submitted the notification. The court has asked him, the government side.
Yes, who is appearing for the?
My lord, to cut it short, if your lordship permits, I'll just show one document. My lord, first of all, let us take the date, my lord. The date election result is on 11/5. I think my brother will agree. 11/5/2025. So if you take the 16 days, over here the General Clauses Act also doesn't come. If you take the 60 days, it is on 9/7/2025. Agreed? And if your lordship take either of the day away, then it comes to 10/7/2025. In the court of District Judge Huzai, a election petition was filed, marked as election petition number 1 on 2nd July 2025. So my friend cannot say that there was no tribunal on that day.
Assailing yours election.
No. Another one. My lord, in the left-hand side, the
down column above the case number, district judge Huzai 1, your lordship got it, left hand side. And right hand side, registration date 2/7. And last date comes to 10/7, that 60 days period. So that was entertained, that was accepted, and it was tribunal district
So
judge.
when was that notification notifying the tribunal?
Yes.
My lord, only thing, that notification came on 4/10/2025. Before the notification, before this district was, Huzai district came, and now, for example, my lord,
When was Huzai district declared? It was much before.
it was much before. My lord, what happened, like at present, from the education side, if we say, then there is no IS office in the Huzai district. It is still in
We
the
are not
Nagaon.
concerned with that.
Okay.
When was the election tribunal under 119 of the Panchayat Act?
4/10/2025.
So 4/10/2025.
So that 60 days period over here, if you take the from the notification date,
it will be from 4/10/2025.
4/10/2025, it will end on 4/12/2025. But what I'm saying, the contention of my friend that there was no election tribunal, that per se cannot be correct, because a election.
No, without the power being conferred on the district judge, how can he entertain an election petition? He cannot.
And that too, lordship.
He cannot get the jurisdiction on himself.
I understand.
What is the basis that he registered 1 of 2025?
That is also, lordship, till date, the government side, on the last date also, they have not produced the this notification. They have not stated before the court that the tribunal was formed on such and such day. Even they have on 28/5 they have stated that the process
My
is
lord,
going.
notification, I've got it. I've got the notification. That is notification number E. My lord, may write it down.
Today also.
My lord, notification number E dash 661268 stroke 9 dated 04/10/2025. Oh, I have a copy. I have a copy.
Abedin is too tech savvy these days.
Yes, yes.
ले दिया इसलिए यदि वो बोली
एकदम लास्ट ऑर्डर की
So how did he register this 1 of 2020?
I don't know.
Cannot be. It can only be after.
If at best within 60 days from 04/10/2025.
But lordship,
if from the date of notification it is taken.
also not disclosed the thing before the court also. On the last date also, court has directed the state council to get this instruction regarding the notification.
This will be by Panchayat.
Only today.
Where is
My lord,
Mr.
only one
Pratap?
thing, what my friend has said regarding that delay condone. There is a judgment of our High Court considering the 2 Supreme Court judgments. If it is a self-contained code and special law, there is question of no limitation, man. My lord, I've just mentioned the date with my own hand because the date was not coming in the thing. The decisions, my lord, the 2 decisions are there already. That is 1969, Venkateshwara Rao, and then AIR 74/480, Hukumdev. And both the judgments are, my lord, quoted here.
You give a copy to Mr. Law. Can somebody get hold of any standing council? Panchayat? Mr. Ullah, you are here, second up.
Yes, Lord.
Mr. Abedin may not be here. It's too much for him to stay two halves in the court.
My additional submission is that one thing is that 129 says the bar. 129 says
Now,
bar.
your
of
question
60
would
days.
be whether the bar would be from the date of the statute, prescribed in the statute, or the notification.
Lordship, so far as notification also, it is not a place before the court itself, before the High Court itself. When I have alleged that there is no tribunal, and till the other day,
No, they might have thought the High Court also concurred to this notification, so High Court knows everything.
Lordship, the Constitutional Department.
Mr. Ullah, get hold of
Panchayat.
standard at two, we will take up.
Okay.
I don't like to keep Mr. Abedin waiting too much in court.
Yes, obliged.
Deeply obliged, my lord. My lord, in the meantime, that judgment, if your lordship gives me, I'll just get it for.
You give it to Mr. Ullah also.
I've given one copy, but I'll get a photocopy done from there, my lord.
Or do one thing, you can give her the number, case number.
Case number is there.
I don't think so. It's the case number. Right?
Writ appeal.
Literally give it back to writ appeal.
I think the printout, my
yes,
lord.
I have forgotten at 2 o'clock. Dr. Khanna has asked me to go there for my checkup of health.
Where is the other side?
I will tell Mr. Sharma. He is in court number 9. I will tell him.
Okay, you leave. When the junior of Mr. Sharma comes, I'll pass the order.
On next,
when?
So this will be on next week, my lord. I will tell him, man. I can tell him.
On 9.
On the way.
Suppose.
On the way, he is in court number 9.
You go have your checkup.
My lord.
We will, when Mr. Sharma or his colleague comes, some junior should be here. We will pass the order.
My lord.
You tell her about that. Next week, let it be in March. 5th would be
March first week, let's say.
First week, 5th, after the Holi.
My lord, yes.
5th.
Of that.
Tentatively fixed, let the
yes.
council.
Matter is very short. I will discuss.
At 2. You will be now saying that the court has kept me in the second half also. Sometimes you have to be here.
Lordship, petitioner is absent. We have filed our affidavit in this matter. No reply has been filed, although time was sought on an earlier occasion. We have filed in 2023 itself.
No, what has happened exactly?
My lord.
Now, whether the license of Ratanboro has also been cancelled?
Lordship.
Cancelled.
Lordship, that
because your page 40
yes.
is an indication that this has been cancelled. What
Lordship,
is this?
There's a at page 38, BTC sent communication by later dated so and so.
No, you can come to 40. That is
Page
explicit. Because there was a status quo order from the school.
Yes.
Violation of that was.
He was tagged with another.
That the whole thing was. Now he says cancelled. So nobody is having a FPS license now.
Yes, my lord.
Neither the petitioner nor the respondent.
Yes.
So if that be the position, you consider.
Yes, it may be done.
You consider.
Lordship, my lord.
But can you just get a clarification on this?
I will.
Can we have it on Thursday?
Day after tomorrow. I'll try to, my lord. Yes.
None appears for the petitioner on call. Ms. P. Bhuya, Learned Senior Counsel and Standing Counsel PTC is present. Ms. Bhuya submits that she would receive instruction as regards the present status of the setting up of a FPS dealership after the license of the respondent number nine was
Nine.
cancelled.
Sorry.
And the beneficiaries were tagged with another FPS dealer, Ripon Busumatavi. So you also receive an instruction whether a fresh license is required or this arrangement can continue.
My
Is
lord.
that much?
Lordship. On Thursday?
Thursday.
My lord.
I will state to list this
Mine.
matter again on Thursday.
My lord.
Okay, by slip
12.
12. এটা আছিল নহয় লছ হ'ব। Have you got a standing counsel?
Call.
Yes, Mr.
Lordship.
This is only with regard to the delay.
Elimination. Yes, Lordship, in this regard, Lordship, in a similar situation, Lordship, this our Honorable High Court, 2005, Lordship, para 5, Lordship, last 6 lines.
What is the citation?
2005 through GLT 409. Lordship, this was also similar, Lordship. It was not constituted at that time.
Constitution.
This may kindly be treated, our petition may kindly be treated as election petition, Lordship. While by that way, my limitation may be kept, Lordship. Because I was not at fault.
Yes, ma'am.
Page 409.
409.
2005 2 GLT. Delay was condoned by the tribunal.
Give me 2 minutes, Mr.
Yes, Lord.
Please have a seat.
That's right.
well reasoned.
Lordship, I have one
Here
more.
also, when was the election declared, results declared?
11/5.
11/5.
11/5/2025.
Lordship, I have one more submission, Lordship.
Yes, Mr.
Lordship, I have one more submission. Under the present fact situation, my petition number 1 and 2 may be allowed to withdraw the claim with liberty. For this matter also, I have
Now that we are sending you to the tribunal or the election tribunal, if we send you, which is the candidate here?
3 and 4.
3 and 4 are candidates.
Yes. Yes. Lordship, in a case in Gauhati High Court, in the same election, Panchayat election, Lordship, prior to the election, 2 writ petitions were filed, one by candidate and one by not by candidate. While disposing the same, the Honorable High Court has observed that the candidate may file this election petition before the tribunal, and the non-candidate who are not candidate may file writ petition before the High Court after the election is over. So my point of view is that so far as 1 and 2 is concerned, they can't go to the tribunal. They have got no right. Whether they are they can't have any.
So the candidate who will be permissible.
Yes. So I would like to withdraw my claim so far as 1 and 2 with a liberty. So we'll come later on. Lordship, that's my submission, Lordship.
Yes, Mr. Abhinav, what do you say?
My lord,
Admittedly, on the day when the writ petition was filed, the election tribunal was not constituted.
yes, understood.
So he had no other way out other than filing a writ petition. So this writ petition was filed immediately within that period of 30 days. So why not, if we direct this now to be considered as a what do you call that? Election petition. Because see, the allegation against you is great. You have given replies that it's a family of the petitioner only. But this has to be tested. So if we remand this back to the tribunal, concerned judicial, to register the same as a
election,
what do you call that?
Election petition.
Election petition, and then proceed in accordance with law, finish it off within a period of time.
Yes.
Do you agree to that?
No, my lord, before I agree, I would like to, your lordship has possibly gone through this judgment of 2005, as my friend has given the thing. But would your lordship be pleased to see my judgment which I have referred? It is of 22 division bench, my lord.
Aslima Khatun?
Yes. So in Aslima Khatun, my lord got it, my lord. In para 6, it is, I'll directly come to para 10. Over here, my lord, the writ petition first was filed challenging an election which was dismissed in limine, and then went and filed the election petition. Election petition ought to have been filed on 6/2/2013.
I got it. It is a situation wherein there was a election tribunal already constituted.
No, what I'm saying, now come to page para 10. Fourth line. My lord got it. The writ court. The read court was also of the view, the respondent number 6, the election petitioner was entitled to take the benefit of section 5, read with section 14 of the Limitation Act to seek condonation of delay in filing the election petition because prior to filing of the writ
This
petition,
may not be the correct position because special statute, when there is no provision for condonation, you cannot read that into that. I think the division bench finally held that you cannot extend the time of limitation.
no, that I'll come to this point directly, my lord, to paragraph 12. The filing, the two admitted facts were that
Para 12,
para 12,
they're not senior counsel.
yeah, it was factual aspects that fifth line, beyond the period of 60 days from the date of declaration of the result of election. Then in the light of these two admitted facts, the two courts below erred in condoning the delay in filing the election petition. Now come to the finding, my lord. Finding, before that, I'll just refer to the two decisions which were referred over
You
here.
can come to the finding of the division bench.
Yeah. Only one thing, my lord, would your lordship be pleased to see that paragraph 17, that last line is the para 14. Para 14 is quoted in next page. And then paragraph 19, that is the Sukhdev's case that was quoted in para 17. Now, the finding is para 20 and 21. Applying the aforementioned principle of law to the election petition filed under the Act, we are of the considered opinion that the provisions of the Limitation Act have no application to the election petition filed under section 129B of the Act. A fortiori, neither section 5 and nor section 14 of the Limitation Act will have application to election petition filed under section 129B of the Act.
Accepted. This is the accepted position.
Now let us come to page 21.
Para 21.
Para 21. On perusal of the scheme of the Act, we find that the Act in question, being a special act, is a complete code in itself and contains special provisions of limitation. Section 129B for filing the election petition to challenge the election is specified under the Act. Secondly, Rule 54 provides that the rules enacted under the Representation of People Act would apply to the Act. Thirdly, the Act does not make any provision to make the Limitation Act applicable to the Act, and hence, so long as there is no provision to make the Limitation Act applicable, no benefit of section 5 or section 14 of the Limitation Act can be taken by the parties while prosecuting election petition under section 129B of the Act. And lastly, once the Supreme Court in two decisions have held that provision of the Limitation Act have no application to the Representation of People Act while prosecuting the election petition under the Representation of People Act, then the necessary corollary, and with the same reasoning, the Limitation Act will not apply to
We got it, Mr. We got it. But the Limitation Act, if we even permit him now to withdraw this petition and file a election petition, he will not be in a position to file it because of the limitation.
Yes.
We are not doing that. We are transmitting this petition to be treated as a election petition.
My lord, that I think will come again, the notification of notification dated, my lord. 410.
Only today disclosed.
It is, I'll just address my honorable court on this. If your lordship looks at the first order, initial order in this writ petition, there the question arose. It was duty of the petitioner to see as to when the notification came, and it is not 1 or 2 days, it is 60 days benefit was given. He ought to have filed within the 2 months of that notification. Then there would have been another ground. Possibly I would not have said what I'm saying now.
Where is that fresh round of limitation in the notification? Is there a limitation period in the notification?
Nothing. It cannot be.
Then
it's a self-contained code. There is no question.
That notification is neither here nor there. So
The last date also.
No. What I'm saying, when the writ petition was moved, on the first day question
Supreme
of
Court, the Constitution says 243 OB, no election shall be called in question except by an election petition presented to such authority in a manner as is provided for by or under any law made by the legislature of the state. Now you will have to come to 119.
129.
129.
129B.
So the law is now this.
That is page 142 and 43. This is the book.
Now. Come to 127.
127.
Constitution.
Yes, my lord.
The government shall constitute panchayat triangle as may be necessary on the recommendation of the High Court to dispose of all direct election petitions challenging elections under this Act. The jurisdiction, powers and functions and headquarters shall be decided by the government in consultation of the except as provided in section 10 of this Act. So 10 says about the deputy commissioner, some exceptions are there.
I may refer to the order of this court dated 28/5.
Just now. So subject to 10, that is with regard to president and vice president, all other matters will have to be thrashed out before the election tribunal. Now the word you see. No election to any panchayat shall be called in question except by an election petition presented within 60 days from the date of declaration of election results to the tribunal constituted under section 127. So till the tribunal is not constituted, whether the period of limitation can run.
So that's what I'm saying.
Cannot.
Yes, it cannot.
But the moment the tribunal comes in, the limitation will
start.
So from 4/10/25, the limitation has started. One. Now, this writ petition was filed in May. There are repeated orders of this court here. Even as late as 28/1/2026, requiring the authorities to bring on record the notification constituting the tribunal. And Mr. Abedin, you were here before this court on which date?
Possibly, my lord, all the dates.
13/8/2025, you were here. You have also not pointed out that fact. That on 4/10, this was constituted.
My lord, whose petition, my lord?
No, that fact, that is a fact.
No, but the fact remains it was...
Even, see, 19/1, 28/1, this court is requiring the...
No, what I'm saying, it was available on online. What I'm saying, on the first day, the question dropped in from this honorable court saying that election petition has to be filed. That time my friend said there was no tribunal. So I think, I leave it to your lordship, but I think that if the question of limitation as my lord is drawing, it can come at best from 4/10 and from...
Admitted, not before.
And beyond that, possibly this division bench will come in and there will be no scope, my lord.
Okay. Now that would be a situation arising if we allow Mr. Ullah to go and file a election petition now.
Yeah.
But if we transfer this petition, admittedly, this is not to be considered by us, then the question of limitation will not come in.
May not.
Will not come. Because this will be a continuation proceeding. This will only be renumbered there. So why we don't do that? And get the issue thrashed out by the tribunal.
Yes.
You think over it. Not rushing you up. You think over it. And Mr. Ullah will give you a decision of this court, Itanagar bench, wherein the same very issue had come up. And it had proceeded even further. After this matter was placed before the tribunal registered, plea was taken by the elected candidate that the plea of limitation was taken. The tribunal rejected it. Like that, again, it came up before the High Court reiterated its earlier order, saying that there can be no question of limitation because it was the writ petition which was within the period of limitation sent.
This is the case, my lord, where division bench, it was first came before the High Court. High Court dismissed in limine. Then the writ petition was filed. The question of limitation was taken, but the election tribunal overruled that and accepted the limitation under section 5 and 14. Then
No,
they
that's true.
But
Because
they-
here
then they came before this honorable court.
I know.
Learned single judge accepted that waiving of that limitation, my
It
lord.
cannot be.
And
It's
then the
rightly decided now.
Yes.
But here, the issue was that the writ petition was allowed to be closed with liberty to the petitioner to file a election petition. Now, Representation of People's Act, Jyoti Basu was not taken consideration. Jyoti Basu's case is also there. Wherein it said, Representation of People's Act is a complete code in itself. You cannot go beyond that. So, filing of a writ petition, election petition fresh there would, again, the limitation would be a bar. But if I transfer this, will that-
possibly a writ cannot be treated as an election petition.
Why?
No, it cannot, because the filing of the election petition has got a different format and before the different court.
This does not have the rigors of the representation of people.
It does. It does, because
You
it
take
is
a plea.
no,
You
what
can
I'm
always
saying,
take a plea.
that Representation of People Act has been explained very well in these two judgments, saying
Representation of People's Act is made applicable, section 54.
yes,
Let us see.
when 129B comes and election matter comes, whatever has to be taken, it is taken in the nature of what is there in the Representation of People Act. And the Representation of People Act, in view of these two judgment, it is totally bars
It is section, not 54.
54 of the rule 54 of the Constitution rule. That is page 222.
You just go through that judgment. Go through that. Yes, Mr. Kumar. This is an election petition. Now, when he filed it, the election tribunal was not constituted. It was constituted much later. And this court, I find, was issuing repeated orders requiring the respondents to receive instructions as to whether the constitution was done.
Absolutely done.
No, it was done in 410 only. Now I find here two things. Mr. Abedin has brought on record a filing details, wherein an election petition was filed on 2/7/2025 at Hojai, District Judge Hojai. But on that day, the tribunal was not constituted.
My lord, that aspect I clarified only one thing. Just for the sake of this honorable court, my lord. My lord, initially, as your lordship has pointed out, that District Hojai was declared long back. It was 15th August 2015. It was declared. What happened, my lord? That time, election tribunal was there. Suddenly, on 31st/12/2022, the Hojai district was again merged with the Nagaon district. Then on 25/8/2023, after 8 months, again declared as a district. So possibly what my lord has said, that why it was accepted, because it was already from 2015.
But after it became a new district, under 27, the declaration was not there.
No, I'm not going into all that. What I'm saying, the one thing that how did it accept?
Okay.
Possibly
And
that is,
because of that flow.
yes, that is the 8 months gap was there when possibly that was not withdrawn from the London district judge, the tribunal power, my lord, election tribunal power.
Yes, Mr. Kumar, what do you think on this? There are two options to us.
Yes.
One, we can dismiss the writ petition saying that this is not maintained. That will not be the Peneka for the whole thing because he has raised some very serious objections, serious things here. Two would be to transfer the writ petition to the tribunal itself. Subject to whatever, other than limitation, all other issues kept open. What do you say?
Your Lordship, second option may be better, Your Lordship. Maybe sent to the tribunal, Your Lordship.
Limitation we will not touch. We'll say limitation cannot be touched, but all other pleas permissible to be taken, objections permissible to be taken, other than this can be taken.
Yes.
No, I'm not forcing you. Think over it. We'll have it on Tuesday.
He never agreed to that one.
No, I just want
No, if I don't agree today, I'll not agree after 1 year also. I'll keep your lordship may give it direction.
No, I'm not on that.
If your lordship gives the direction, limitation will be waived. That is another thing.
No. Mr. Abedin, I'm not asking you to agree. I will, even if you agree, I'll not record it. One. What I'm trying to do is, this is for my benefit.
Yes.
I'm trying to have the contrary view. That's all.
Okay.
You give me the contrary view. What would be the pitfalls there?
One primary thing, whether writ petition can be treated as an election petition. If
that you leave it to us, we have the power. Once we direct, we'll hold it. But go further. What would be, whether there is a bar, you just do some research, come back. A contrarian view. What would be that?
Okay.
But Mr. T. Learned Counsel for the petitioner also heard Mr. K.K. Learned Additional Advocate General appearing for the state respondents. Also heard Mr. J. Abedin Learned Counsel appearing for the respondent number 6. Hearing remains inconclusive. Registry to list this matter again on Mangalwar, 17.
I think after
17.
another week, bit work has to be done.
Okay, when?
In the last part of the February, my lord.
Okay, 24.
Either 24 or 26.
Whenever it's convenient. 26.
Yes.
26 to 2026. I'll also read in the meantime.
My lord, what
so,
is,
like you also
yes.
just research. It's not a case as an officer of the court, you just said.
My lord, what is that judgment your lordship said I have to go through that? Aruna?
So, will give you.
Deeply obliged. My lord, Pathad.
again. No, this is so much. Sorry. So in the morning, R.C. Sekesa was very eager to do the matter.
Yes.
But subsequently, he made a prayer that he is having some health issues. He's going for a checkup.
Medical check.
Without hearing you, I did not want to adjourn the matter. But I assured him that I'll not take up. When it is convenient? He said 5-2.
5-2.
5-3, sorry, sir.
5-3, my lord, I have another case fixed.
When on
10th
10.
Tuesday.
Now tell me one thing for my consumption. Here, you have challenged the draft chita. You have submitted. What happened to that proceeding?
Well, originally, draft chita, the name of Parasuram was there as the owner of the land. But when the ADC dismissed their application that the Kanura, the respondent number 6 is not the heirs of Kanura, then they preferred an appeal before the Board of Revenue.
Then the tribunal came.
Board of Revenue, in the meantime, they have managed the Mandal and others.
It's a subsequent development.
Subsequent development.
And Mondal has
Even a report.
note that the name of Parasuram was recorded as the heir of Kanu. Kanuram is the father of Parasuram. So he has come filed his application. And the Board of Revenue held that it is an administrative error. Therefore, their appeal was allowed.
And he says that he is in possession of that land.
Possession is different thing.
I
It's
just
like-
want to know.
No, he is not in possession.
But this court has also passed an interim direction that the peaceful possession of the respondent number 6 be not disturbed.
That was they have stated, but I inquired that the
Now,
land,
sir, one thing, they have
some
filed an,
portion of the land, of course, they have occupied.
they have filed an affidavit. In that affidavit, para 5, 6, everything is in your favor.
Yes, yes.
He has admitted everything.
Yes.
Now, thereafter, they have filed an additional affidavit saying that this is an error. Whether that additional affidavit can correct the affidavit proper,
No.
or there has to be an amendment application filed.
There has to be an amendment application.
Is that's the procedure? They have not filed an application for amendment.
Amendment.
So how do this court? Now there are two affidavits, one affidavit proper and an additional affidavit. Contradictory things. Because say that I did not mean to say this, I did not mean to say this, that much only. Now in such a situation, they have not filed a amendment application. Tomorrow the matter is taken up by me for hearing. How do I construe that affidavit and the additional level? How I have to go pursue?
So if their application for correction is allowed, then they have to file.
Because they have not filed an application for correction.
Correction they have filed.
No, they have filed an additional affidavit only.
Oh, correction. Not they want to introduce the word not.
Word not. But here, whether that additional affidavit will do.
No, that application.
Because
Correction should be there.
Correction should be what? An interlocutory application, amendment or correction, or this affidavit will do.
So this affidavit will not do.
Because they have filed an affidavit. After going through the affidavit and reply, it is found that a typing mistake has crept in.
Yes.
Para 5 of the affidavit. This will do.
That will not do. That has to be allowed.
Allowed. But how can I allow an additional affidavit?
No, your lordship only allow the correction.
I
Then
can
your
allow.
lordship allow the correction, then they are to direct it to file a fresh affidavit.
On the basis of this application, I
This
can allow. Much only. So next date we will allow that, ask them to file. Heard Mr. A.C. Sharma, learned senior counsel, assisted by Mr. P. Deuri, learned counsel for the petition. Also heard Mr. R.C. Soikia, learned senior counsel. Also heard Mr. H. Sharma, learned government advocate, appearing for the state respondents, and Mr. R.C. Soikia, learned senior counsel, assisted by Ms.
M. Sharma.
M. Sharma, appearing for the respondent number 6. As agreed to by the learned counsel for the parties of history to list this matter again on 10/3/2026 for admission here.
Next.
Just inform 10/6 to serve. Yeah. hold on. Why is it not doing it? What is 12 12 material? Item number 12. Yes, madam.
Lordship senior counsel is online VC in Itanagar branch, Lordship. So it will take time. So kindly fix the matter, Lordship, on Friday.
Sorry. We have got our instructions here. We are going to pass orders. We are waiting. We are here. Asking to come. The matter will not take long time. It will be. Madam, the records are perused. The statements are not there.
Oh.
The statement is not there. It's just a record to us, you know. Madam, you go through that. Just take your time. Go through that. By the time we'll pass 2 orders. No, 20 to 22. Ms. Sharma, any PP has come?
He will come.
Heard Ms. M. Hazarika, learned senior counsel, assisted by Ms.
Vivi Tanya, Your Honor.
Vivi,
Tanya.
learned counsel for the petitioner. Also heard Mr. A. Bhattaji, learned standing counsel, revenue and disaster management, appearing for all the respondents.
No, I appear for respondent number one.
And Mr. H. Sharma, learned additional senior government advocate, appearing for the respondent number 2 and 3. The petitioner, by way of instituting the present proceeding, has assailed an order dated 8/5/2008, passed by the settlement officer. Gauhati in Miss case number 95/07-08, cancelling the mutation effected in favor of the petitioner with regard to the lands brought by him from Messrs. T's, Beef Growers and Manufacturing Company Private Limited. Also, the petitioner one Messrs. Tea Leaf Growers and Manufacturing Private Limited was upon private limited, upon payment of premium, was settled with a plot of land measuring 20 bighas 7 lessas covered by DAG number 704 bracketed part. The said DAG was subsequently renumbered as DAG number 111114. Also, out of the said plot of land, parcel of land as settled with Messrs. Tea Leaf Growers and Manufacturing Private Limited, a plot of land measuring 5 bighas was transferred to the petitioner hearing, while two deeds of sale dated. Those deeds of sale being sale deed number 10886/2024 and sale deed number 10887 of 2004, both dated 31/12/2004. Also, thereafter, the petitioner hearing applying for mutation of his name against the plot of land now bought by him from Messrs. Tea Leaf Growers and Manufacturing Private Limited. Accordingly, the name of the petitioner was recorded in the land records, and he consents to have been paying land dues for the plot of land under his possession, as the owner of the same. Also, the petitioner thereafter applied for permission to transfer the plot of land as bought by him from Messrs. Tea Leaf Growers and Manufacturing Private Limited to 7 other individuals. Also, the permission for the said transfer was duly granted by the Deputy Commissioner, Kamrup, Wide and order dated 23/9/2005. Also, the petitioner thereafter projects to have applied before the Gauhati Metropolitan Development Authority (GMDA) on 9/11/2005, seeking permission to transfer the 5 acres of land to 7 other individuals, and such permission was duly granted to the petitioner by the GMDA authorities vide a no objection certificate dated 29/11/2005. Accordingly, basing on the said permission granted by the Deputy Commissioner Kamrup and the no objection certificate issued by the GMDA authorities, the petitioner transferred the said land to 5 other individuals. Also, next subparagraph. When the purchasers of the land from the petitioner hearing applied for getting their names mutated in the land records, comma, the buyers of the land from the petition on approaching the concerned authorities for mutation of their names in the land records, comma, they were informed that they were required to clear the land revenue dues. However, the petitioners thereafter proceeded to clear the land dues. Also, it was also informed to the said buyers, that such deposit would be permissible to be made only by the persons whose name figure in the land records. Also, accordingly, the buyers proceeded to make the payment in the name of the petitioner herein, and it was then that they were informed that the petitioner's name was cancelled from the land records by virtue of an order passed by the settlement officer in miss case number 95/07-08 dated 8/5/2008, and as such, they were prevented from paying the land revenue dues. Also, accordingly, the application submitted by the said buyers for mutation of their names in the land records could also not be taken forward. Also, the petitioner, on being informed about the deletion of his name from the land records after his name was so mutated against the land purchased by him, comma, he made an inquiry, and in the inquiry it was revealed that the order dated 8/5/2008 passed by the settlement officer, Gauhati, was so passed in pursuance to a circular issued by the additional Chief Secretary to the Government of Assam Revenue Department dated 5/12/2006, wherein a stipulation was made to the effect that land settled or converted to periodic patta on realization of premium shall not be permitted to be transferred by way of sale, mortgage, comma, lease, or comma, gift for a period of 10 years from the date of issuance of the settlement order or from the date of taking over possession, whichever is later. Being aggrieved, the petitioner has instituted the present petition. Also, Ms. M. Hazarika, Learned Senior Counsel, by reiterating the facts noticed herein above, has submitted that the name of the petitioner duly being incorporated by way of mutation in the land records, comma, prior to cancellation of the same by the settlement officer while issuance of the order dated 8/5/2008, he was not given any notice in this connection, and thereby he was prevented from having is say. Therein, she further submits that the cancellation was so effective basing on a circular dated 5 5/12/2006. Also, he submits that he had purchased the land in question from Messrs. Leaf Growers and Manufacturing Private Limited, and on such purchase, his name was mutated in the land records to the extent of the land. Now, land he had become owner on the execution of the sale deed question, was so effective much prior to 5/12/2006. She further submits that the petitioner had sold the land, sold the said land to 7 buyers. Also prior to 5/12/2006, after due permission for the same was received as well as a note from the GMDA authorities. She submits that the stipulations made in the 5/12/2006 could not have been given a retrospective effect, so as to also bring within its fold concluded transactions taking place much prior to the date of issuance of the circular dated 5/12/2006. In view of in the above premises, the above premises, Ms. Historical and senior, it's that while the objective of the prohibitory order is laudable, the same could not have been given a retrospective effect, accordingly, she submits that the cancellation of the order dated 8/5/2008 passed by the settlement officer Gauhati in this case number so and so would mandate an interference from this court. Per contra, Mr. A. Bhattaji, learned standing counsel, revenue and disaster management, appearing for the respond number 1, submits that the land in question was settled with Messrs. Leaf Growers and Manufacturing Private Limited at a concessional rate
at page 46 line, Lordship.
Huh?
At page 46.
Also, he submits that the circular dated 5/12/2006 was so issued for ensuring that the lands so settled by way of realization of premium with organizations / individuals for the purpose of sustaining such organizations or individuals, in the in the event the organization / individual so settled with the land is permitted to sell the same to some others, thereby rendering the organization / individual landless and/or frustrating the objective for which such settlement was so made, would not be in the tune of the spirit of the government objective behind settlement of settlement of land in such manner. He further submits that the circular dated 5/12/2006 was also issued to ensure that land would not be concentrated in the hands of few individuals, which may create problems in times to come by way of abnormal increase in the land prices. Also, accordingly, he submits that the government had introduced a stipulation to the effect that lands which were so settled on realization of premium shall not be permissible. Land shall not be transferred by way of sale, mortgage, lease, deed, etc. for a period of 10 years from the date of issue of the settlement order or from the date of taking over possession, whichever is later. He submits that although the circular was so issued on 5/12/2006, the said circular was made applicable to all settlements made earlier which have not completed 10-year period. Also, he submits that the land settled with Messrs. P. Leaf Growers and Manufacturing Private Limited on the date it was so transferred to the petitioner hearing, having not completed, being within the period of 10 years, the bar as introduced by the circular dated 5/12/2006 would stand attracted, and accordingly, the cancellation of the mutation of the petitioner by the settlement officer wide the order dated so and so in this case number so would not mandate any interference. Anything more? That's it. I have heard the learned counsel for the parties and perused the materials available on record. Observe. 9, 10. The material. Madam had given me 2 decisions.
Your Honor.
Is Bharat Sanchar
Yes, Your Honor.
And?
Paragraph 30, yes, Your Honor. Today we have submitted this.
and the next one?
Okay. I think we just submitted one citation on it.
Only one,
Effective paragraph is paragraph 30.
Bharat 30.
Yes, Your Honor.
Paragraph followed my in support of the said conclusion, this court relies on the decision of the Honorable Supreme Court in the case of Bharat Sanchar Nigam Limited, others versus Tata Communication. Also, para 30 of the said decision, being relevant is extracted here. Extract with 42. Correction. Once we finalize this, the other 2 will follow. Interdisposal. You'll get the order by Thursday.
Much.
Statement is, sir.
The orange flag, Lordship. But there is little bit hazy, Lordship, as this from print from the e-office, Lordship.
This is the only thing.
Yes, Lordship, statement.
Yes, madam. He has not admitted to the charges. He has given an explanation.
Explanation.
And you have not dealt with that explanation.
But one more thing, Lordship, as per the prevailing service rule, Lordship, there are even notification also. Once transferred, Lordship have to be, that means have to join their Lordship. Then
You deduct don't pay him the salaries for that period. Fix that period notional. He will not come in. But withholding of pension for that purpose.
no, the other papers are Lordship. This is on last occasion I have submitted before your Lordship. They already have processed Lordship these things.
Where? What happened for him?
Oh, that I have not, that means
You have
taken any
given back
instruction.
everything to him.
Paid or not paid, that I am not aware, Lordship,
got
but they have moved the application. These things they have submitted, I think, with the AG Lordship. Most probably what they conveyed, Lordship.
What are they doing? That they will review that order.
No, Lordship,
Of course,
regarding the
then
other
that order
things, Lordship.
in existence, by following that order, they are now finalizing his pension
Yes,
and
yes,
pension benefits.
Yes.
These
You're not
are
getting
the
pension.
the other Lordship, the benefits, Lordship, regarding this.
But this order, they are not reviewing. This order will remain as that.
Revenge.
And whatever he gets, he will be paid. That's what you want to say.
Lordship.
Ask them to expedite that. In the meantime, we'll finalize this.
Okay. Lordship,
Lordship,
fixing any date, Lordship,
today
so
is
that
my
I
last-
can update on
Today
this.
is my last court. I am going to join as an assistant PPE, Lordship. Lordship,
But
matter of
Mr.
disposal.
But Mr. You are pulling
GC Bora.
the GC Bora, Learned Counsel for the petition. Also heard Mr. M. Bachaji, Learned Additional Senior Government. Ms. Bachaji has produced the case, has produced the records in original, has produced the departmental proceeding records. So the same is taken. Has produced the departmental proceeding file and the same is taken on record. So hearing concluded, judgment reserved. You're free. And I'm still this side. I'll go through it once.
Lordship.
Because you have not followed the procedure.
Lordship, I have submitted two judgments.
Rup Singh Negi and Bijlani.
Bijlani, yeah. All right.
How will you know when we deliver the judgment?
Okay.
How will you know when we deliver the judgment? How will you get to know?
On earlier date.
No. Say I delivered this judgment on a particular date. How will you know? Where will you be joining as additional PP?
Okay, tomorrow.
Where?
Tomorrow appointment letter was issued by the.
No. Where will you be posting me?
I don't know.
It can be anywhere.
Anywhere.
Anyway, congratulations and do well. It's a good field. Do well. Anyway, ask your friends to be in touch so that you also get to learn when we pass the order. And we'll pass it very shortly. Don't.
All right, thank you.
Lordship, hearing is still going on. Lordship,
The matter was taken up for hearing. This was called up in the first half and the matter is again taken up during the second half. It is submitted by the learned counsel appearing on behalf of the arguing counsel, Mr. A.K. Proceedings, that the arguing counsel is on legs in connection with some other matters. Also, considering the said position, the matter stands adjourned to Thursday, 12 2026. No further adjournment shall be granted in the matter. And madam, you are not here in the morning, I'm dismissing the petition. It's a matter of 2018. We are not keeping it for me. Person. Yes, Mr. Borua, what do you say about this?
What's the query was that, my lord? The incident of 2018, my lord. I'm sorry, my lord. Yes, 2018 June, my lord. When the my lord, girl, my lord, she was, my lord, having some problem, my lord. And after that, my lord, she was taken to hospital, my lord, wherein it was, my lord, detected that she is having, my lord, 16-week pregnancy, my lord. Now, lordship's query was that on the last occasion, after hearing the matter, my lord, that doctors, PW10 doctor says, my lord, the doctor says the victim was 16 week plus minus, my lord, 2, my lord, pregnancy, my lord. That means, my lord, she was carrying, my lord, for 4 months, my lord. 16 weeks means 4 months, my lord. So, my lord, if the incident of, my lord, alleged incident of June 2018, my lord, and doctor examined, my lord, on 2/9/2018, my lord. That is in the month of September, my lord, she was examined, my lord, wherein it was detected that she was 4 months pregnant, my lord. Then incident will have to be, my lord, probably, my lord, August,
4 months prior to that.
July, June, May, my lord. May. Now, my lord, all the witnesses, my lord, they have said, my lord, because as per the victim's evidence, my lord, it is clear, my lord. He has, my lord, accused has committed rape, my lord. And she is a, my lord, not a, my lord, normal person, my lord. She is a defender, my lord. That is why, my lord, we had to, my lord, give evidence through a translator, my lord.
But all the date given by the witness are contradictory.
Contradictory, my lord. Somebody said it's a prior to 1.5 years ago. Somebody said 1 year ago, my lord. That are the some contradictions that is, or say wanted to know, my lord. They kindly go to the record. And what is the evidence of the doctor's evidence, my lord, that she was pregnant when she was first examined by doctor, that she was pregnant for 16 weeks, my lord. And I have just calculated, my lord, as per the, my lord, evidence of the, my lord, witnesses, my lord. That incident may be, my lord, if it is carrying for last full 16 weeks, my lord, then incident have to be in the month of May, my lord. Then only, my
There
lord.
is no conclusion.
PW10 is the doctor, my lord. And 6 is the victim, my lord.
Otherwise, if it is true, it's very heinous. That too with a girl not having this.
And my lord, the accused, my lord, he is a, my lord, at that point of time, he was probably even more
60,
He was 60, my lord, at the relevant point of time.
something like.
2018.
He was behind, from the date of arrest, he was there.
Behind the bars.
Yes, almost 7.5 years.
60 years on 6/1/2020.
Yes.
So he is around 65 now. No, baby born?
That knowledge, I do not have.
Baby born.
Any
Evidence
PW1 to
DNA, etc.
DNA?
No, nothing in this.
Can we not direct for that DNA exam?
Baby lodged.
It will be again, my lord, retrial, my lord. That.
Supreme Court decisions are there. We can ask the district judge to have the blood samples taken in a particular manner, controlled atmosphere, and then sent.
Who know about them, my lord?
But whether the girl is traceable.
No, that also not, no. Because is it 376, their presence is not required before the honorable court. Had it been POCSO, their presence is required. So whether, what is the present status, nobody knows.
We'll go with this. His ban was for 5 years.
After judgment, prior to the all total, he is around 7 years, 5 months,
And the imprisonment is 10 years.
10 years.
Bill. Let him go. But the learner council for the parties at some length. Just putting it for further hearing, but I'll pass the order here. Hearing remains inconclusive. Registry to list this matter again. Ana Khalid India's 26 to 2026. Mr. Burwa,
My lord.
can you just give me small notes, just to your opinion on this? Just a small,
My lord.
not be a formal one, just for my
My lord.
consumption.